All right, everybody, welcome to the Law of Self-Defense show for Sunday, February 13th, 2022. And today we're going to be talking about the law and the legal arguments we should be prepared for the Curtis Reeves trial. This is the popcorn movie trial taking place starting tomorrow with opening arguments. So let me flip over here. All right. Hey, folks. So Curtis Reeves, any of you have been following will know about this case, but we'll cover the basic facts. So Curtis Reeves and his wife, Vivian, go to see a movie in Florida, Tampa area of Florida at the Wesley Chapel Theater. They go to see Lone Survivor, and they arrive at the theater and they take what they describe as their normal seats. Curtis Reeves is a retired police officer, former SWAT captain. Are the eyes bloodshot? Sorry, folks. Just got up myself. They go to the Wesley Chapel movie theater to watch Lone Survivor. This would be in 2014, January 13th, 2014. So 8 years ago last month. And in front of them sits Chad Oulson and his wife, Nicole Oulson. They're married, parents of a 2-year-old at the time. And they're also there to watch Lone Survivor. They take the seats immediately in front of Curtis Reeves in a mostly empty theater, but I guess maybe they were favorably positioned seats. Theater. And Chad, while they're waiting for the movie to come on, gets on his phone and starts interneting on his cell phone. Curtis Reeves sitting behind him, can see this, takes offense, asks him to get off his phone. And Chad Oulson responds that, well, he's texting to his daughter, or really to his babysitter. This turns out to be a lie, by the way. He's not. He's texting various gambling or betting websites, but he tells Curtis Reeves, hey, back off. I'm texting the babysitter. Curtis Reeves, unsatisfied, goes and finds an employee of the theater outside in the lobby. The employee decides not to intervene. Unsatisfied, Curtis Reeves goes back to his seat. Tells at that point, Chad Oulson is off his smartphone. Curtis Reeves says, "Oh, I see you're off your phone now." He told Chad Oulson, "I see you're off your phone now. Sorry about that. I got management involved." And a verbal confrontation begins and escalates between the two men. Of course, this is who starts what is disputed by the parties. Who is being reasonable is disputed by the parties. But at some point, Chad Oulson stands up, turns around, grabs Curtis Reeves' bin of popcorn, takes it, and hurls it at him. Apparently, also hurls his cell phone at Curtis Reeves. And Curtis Reeves will say that Chad Oulson struck him in the head hard enough that it felt like Chad had some object in his hand, perhaps a cell phone, perhaps something else. We do know that there's no evidence that Chad Oulson was ever armed with a weapon in particular. But nevertheless, after being struck in the head, Curtis Reeves says, he drew his own pistol, a 380 caliber pistol, and fires a single shot into the chest of Chad Oulson. At this point, Chad's wife, Nicole, had put her hand over her husband's chest, perhaps to hold him back. But when Curtis Reeves fires that single 380 shot, the bullet actually passes through Nicole's hand into Chad's chest. So she's injured, has some permanent damage to her finger, as I understand it. I believe the wound actually struck her wedding ring. At least that's what her civil attorney claims, perhaps just to make things more dramatic. We don't really know. But in any case, Nicole is shot through the hand. The bullet passes into Chad Oulson's chest, causing a mortal injury. Chad Oulson would die over the next few minutes in the arms of his wife there in the movie theater. And as a result of all this, Curtis Reeves has been charged with 2 crimes, murder in the second degree and aggravated battery. The aggravated battery as of course the murder is for Chad Oulson. That's who he killed. The aggravated battery is for the injury caused to Nicole Oulson when she was shot through the hand by the bullet that would mortally wound her husband. So two different charges, two different victims here. Both serious charges, serious felony charges. Both of them subject to substantial sentencing escalation because of Florida's rather infamous 1020 life statute that applies to mostly crimes of violence that happen to be committed with a gun. And there's different degrees of escalation of the sentence depending on whether the gun was merely wielded, the gun was actually fired, or the gun was fired with lethal effect or serious bodily injury effect, deadly force effect. And we're going to take a look at all of these. So we'll take a look at the information, the sworn document that specifies the charges against Curtis Reeves, this second-degree murder and this aggravated battery charge. We'll look at the statutes for those charges. We'll look at the sentencing escalation statute. And then we'll look at some of the defense statutes, self-defense, Florida's core self-defense statute, another related statute that the defense is referring that involves self-defense. We'll look at the forcible felony statute, and we'll look at a somewhat unusual statute that Florida has that escalates what would have been a misdemeanor battery to a felony battery, an aggravated battery, if the victim of the battery is 65 years of age or older. And Curtis Reeves was here at the time 71 years of age, so this statute would apply to him. So that's what we're looking at for the first part of today's show. And then if time permits, and as time permits, we'll take a look at some of the legal argument that was made at the self-defense immunity hearing for this case roughly 5 years ago. So in 2017, Curtis Reeves demanded and received a self-defense immunity hearing. Florida is one of the states that allows for self-defense immunity. And in effect, this hearing becomes kind of a mini trial. There's no jury. No jury is selected until the trial itself. We just had the jury selected this past week, of course. But at the hearing, there's no jury. So there's the parties, the state and the defense. There's the judge, of course, presiding over the hearing. And the judge will play the role of the jury at the hearing. She'll be the finder of fact for the self-defense immunity hearing. And at that hearing, by the legal standard in effect in 2017, it's changed since then. But in effect, the defense argues for self-defense as a justification, a legal defense against these criminal charges. The state argues against self-defense. And if the defense can convince the judge, the hearing judge, by, at the time, a preponderance of the evidence that it was self-defense, the judge will grant the defendant immunity from criminal prosecution. It's also possible to get immunity from civil liability, from civil suit, but that would require that the whoever the civil plaintiff might be was also present. It would really be a different hearing under current Florida law. Obviously, whoever would be a plaintiff, whoever believes they were wrongfully injured and is looking for damages, they get to be a participant in this hearing as well, if we're talking about stripping them of their day in court, of granting the defendant immunity from civil liability. But in this particular case, it wasn't about that. It was only about criminal liability. And as it happens, the judge, who's also the trial judge for this trial, with opening statements starting tomorrow, Susan Bartle, the judge at the self-defense immunity hearing 5 years ago decided the defense had not proven self-defense by a preponderance of the evidence, and therefore she declined to grant immunity. But what makes the self-defense immunity hearing interesting, and it was very much like a mini trial, it was essentially 2 weeks of self-defense immunity hearing. 2 weeks, 2 full weeks. I mean, most full-blown murder trials don't take 2 weeks. Most murder trials take 2 days, perhaps 3 days. But this self-defense immunity hearing itself took really 2 days of court time. And that's without having to pick a jury. And that's with the parties arguing to a judge, not arguing to a jury. So what's interesting there is we actually begin the hearing with a form of opening arguments. And we end that self-defense immunity hearing with a form of closing arguments by the parties. And the facts in this case haven't changed since the event occurred in 2014. And the law has changed a little bit, but we will be applying the law as it existed in 2014 when this event occurred. We'll talk about that in a minute. Some of Florida's self-defense law has changed substantially in the intervening time. So the Florida self-defense law that will apply to this case, the Curtis Reeves case, is different than the statutory language you would find if you looked it up today at the current self-defense statutes. The statutes in 2014 were different. They've changed. In 2017, there was a fairly major revision to Florida self-defense law. So it's the older version. So you do have to be careful about that. We have to be careful about that. I saw the court getting confused about this past week, which is ridiculous for legal professionals to be confused on this point, especially since Judge Bartle's been dealing with this case since at least 2017 when the self-defense immunity hearing was held, over which she presided. But nevertheless, I would expect, because the facts and the law are pretty well established in this case, the facts may be disputed, but the various versions are known to everyone at this point. I would expect that the opening and closing arguments that were made for the self-defense immunity hearing are essentially going to be identical to what we should expect to hear in the trial starting tomorrow morning when the parties engage in opening arguments. So that's what we're going to do. I'm going to pull up the sworn information that specifies the criminal charges against Curtis Reeves. Then we'll look at the statutes behind those criminal charges, explain how those work. We'll look at the self-defense statutes and other statutes that would be relevant to the legal defense of justification in this case. And then, time permitting, we'll proceed into the opening statements and the closing arguments of the parties from the 2017 self-defense immunity hearing. So that's what you should all expect today. We will definitely be done by early afternoon, my time, which is hours from now. So this could be a pretty long show, folks. But I've been... my lovely wife, Emily, has committed me to attend a Super Bowl party this afternoon by some of our neighbors. I'm not much of a football fan, but these are the kinds of social obligations one spouse will prepare for one, whether you follow football or not. Before we proceed any further, I do want to mention the sponsor of today's show, which is CCW Safe, a provider of legal service memberships. What many people mistakenly call self-defense insurance. In effect, CCW Safe pays the legal expenses of their members when the member is involved in a use of force event and facing criminal or civil liability. And those legal expenses start big and get bigger fast, folks. If you just look at the Curtis Reeves case, he's got 3 attorneys sitting with him, 3 defense attorneys. They've been working on this case since 2014. They've already done a 2-week self-defense immunity hearing. They just spent the last week in jury selection, and they have a trial starting tomorrow that will probably last a couple of weeks. Again, this is all tremendously expensive, folks. Those attorneys are well paid criminal defense attorneys. It's not unusual in a killing charge case like this for the defense to burn through $200,000 before they even get to trial. In this Curtis Reeves case, they probably burned through quite a bit more than that, given the time involved. So it can be helpful if you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself. It could be helpful to have a financial partner behind you to make sure you have the resources you need to fight the legal battle the way you'd want it fought. And that's as if the rest of your life depended on it, because it really does, folks. We'd like to think we live in a country where how many resources you can bring to the legal battle doesn't affect the justice you get, but that is the world we live in. The resources matter, and CCW Safe can ensure that you have the necessary resources. Now, I've looked at all the companies that offer similar services. As you might imagine, I found that CCW Safe is by far the best fit for me. I'm personally a member. My wife, Emily, is personally a member of CCW Safe. Whether they're the best fit for you is something only you can decide, but we do encourage you to take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member, you can save 10% off your membership there using the discount code LOSD10. That's LOSD for Law of Self-Defense and the number 10. at that URL, lawofselfdefense.com/ccwsafe. Okay, that's it for our sponsorship. Let me see if I can turn off these notifications that keep coming up on my computer. And let's start to pull up some of these documents that we're going to use today on the browser so I can share them with all of you. As always, folks, if you have questions or comments, questions you'd like answered or comments you'd like read during the show, I would encourage you to put those into Super Chat form. There's a lot of comments that stream in, and the Super Chat, the way they're colored and bolded, makes them stand out as the more important, so I can make sure I address those directly. Yeah, this is not the trial, folks. The trial starts on tomorrow, on Monday. So here is, first I'll pull up the amended information. This is the sworn document that specifies the charges against So this is the information. I'll make it larger when I start reading through it, but I also want to pull up the statutes that it references so we can talk about those as they come up. I'll pull those up. And all of these are on the Law of Self-Defense website, folks. So I'll pull up the murder statute. I'll pull up the aggravated battery statute, and I'll pull up the sentencing enhancement statute. This is Florida's 1020 life statute. Okay, so here's the sworn information. So I'm going to make that a little bigger. And it has it's sworn out by a state attorney for the 6th Judicial Circuit of Florida. This is a prosecutor. Doesn't really matter who does it, but of course they need to be specified. And we have 2 counts, 2 criminal counts against Curtis Reeves, the defendant here, the retired police officer. One of those is for second-degree murder. It doesn't say second-degree murder, I don't believe. But the phrasing used here is the phrasing of second-degree murder in the statute. And of course, it does reference the statute. It references both the murder statute, which is 782.04, and it references the 1020 life sentencing enhancement statute, which is 775.087. So in effect, it reads that on January 13th of 2014, that Curtis Reeves unlawfully, by an act imminently dangerous to another and evincing a depraved mind, regardless of human life, but without a premeditated design to effect the death of any particular individual. So this depraved mind killing is the second-degree murder. The reason it says, but without a premeditated design, is because under Florida law, if you had a premeditated design, not just intent, but premeditation, you planned it out ahead of time, the killing, that would make it first-degree murder. So they're not claiming first-degree here. They're not claiming premeditation. They're merely claiming a depraved mind, which simply means you intentionally wanted to kill somebody without legal justification. So that makes it second-degree murder. So evincing a depraved mind, regardless of human life, but without a premeditated design to effect the death of any particular individual, did kill Chad Oulson by shooting Chad Oulson with a firearm. And during the commission of the offense, Curtis Reeves actually possessed and discharged a firearm. And as a result of the discharge, death or great bodily harm was inflicted upon Chad Oulson. Now, you may wonder, this sounds repetitive, but one of these is the facts that support the second-degree murder charge. That's with evincing a depraved mind, regardless of human life, but without a premeditated design to effect the death of any particular individual, did kill Chad Oulson by shooting Chad Oulson with a firearm. That's the second-degree murder fact pattern. The state also wants to bring into play the 1020 life sentencing enhancement, and that requires that a gun was used and discharged with lethal effect. So that's why the fact pattern here appears repetitive. And during the commission of the offense, Curtis Reeves actually possessed and discharged a firearm, and as a result of this discharge, death or great bodily harm was inflicted upon Chad Oulson. That will trigger the sentencing enhancement of 1020 life, the gun sentencing enhancement. And then it references both the murder statute 782.04, subparagraph 2, which is second-degree murder, because this murder statute covers all degrees of murder, first degree, second degree, third degree. And it references 775.087, which is the gun sentencing enhancement statute. So let's take a look at those then. So 782.04, section 2. Now, section 1, well, I need to change this. Okay. First, I need to, I guess, stop that and do this and do this. Well, that's a little small, huh? Okay, let me see if I can make that. So here we go. 782.04 is Florida's murder statute, covers all degrees of murder. Subparagraph 1 here is first degree murder. We don't need to focus on that. Subparagraph 2 is the second degree murder, and it reads: the unlawful killing of a human being when perpetrated by any act eminently dangerous to another and evincing a depraved mind, regardless of human life. You can see it now echoing the language of the information we just looked at, or more accurately, the information reflects this statutory language, but without any premeditated design to effect the death of any particular individual. That's murder in the second degree and constitutes a felony of the first degree, punishable by a term of years not exceeding life, or as provided by other sentencing provisions. So normally a first degree felony under Florida law is punishable by up to 30 years in prison. So a potential 30-year to life sentence. Of course, for Curtis Reeves, he's currently 79 years old. So really any time in prison is a life sentence. But that's how second degree murder usually works: 30 years to life in prison as a first degree felony. But if you use a gun to commit the second degree murder, you're also subject to the gun sentencing enhancement 775.087. We'll take a look at that next. And the reason that's important is because the sentencing for a first degree felony, the judge has a lot of discretion in sentencing. It could be 30 years to life. It could be 30 years of probation and no prison time. That's an option. It could be a fine, $15,000 fine. Also an option. So there's a lot of discretion by the judge. So if Curtis Reeves were simply convicted on second degree murder under this statute, in theory, he could do no prison time at all. Perhaps the judge would take into consideration his age, his service as a career law enforcement officer, who knows? But the potential for no prison time would exist. The gun sentencing enhancement takes that away, that option of no prison time, because it requires mandatory minimum sentencing. So let's take a look at how that works. If we go back to the information, we can see that a couple of the gun sentencing enhancement provisions are mentioned: 775.087, section 1, and 775.087, section 2A3. So 1 and 2A3. So let's take a look at 1 and 2A3 of that statute. So here is 775.087, the gun sentencing enhancement statute, and section 1 provides that where a offense would normally have been a felony of the first degree, which is what second degree murder is under Florida law, if the defendant carries, displays, uses, threatens to use, or attempts to use any weapon or firearm during the commission of such felony, and in effect commits an aggravated battery, which of course is charged here as well, the felony that they'll be charged with and ultimately convicted of, if it would have been a first-degree felony, becomes a life felony. So instead of being subject to 30 years for second-degree murder, you're subject to life in prison without possibility of early release. So this is that section 1 as applies to Curtis Reeves for the shooting of Chad Oulson. He's immediately subject to a potential life felony instead of merely a felony of first degree under the gun sentencing enhancement. But then there was also that section 2A3 of this statute that's cited in the information. So here is 2A. We go down to 3, and it reads, any person who's convicted of a felony or attempt to commit a felony listed in the paragraphs above. That's this enumerated list of felonies here, but one of those is murder. Another is aggravated battery. Those are the 2 crimes with which Curtis Reeves is charged. So anyone who's convicted of murder or aggravated battery, regardless of whether the use of a weapon is an element of the felony, and it's not in either case, you don't have to have used a weapon to be guilty of murder or aggravated battery. And during the commission of the felony, such person discharged a firearm. And as a result of the discharge, death or great bodily harm was inflicted upon the person. The convicted person shall be sentenced to a minimum term of imprisonment of not less than 25 years and not more than a term of life in prison. So this is a mandatory minimum 25-year sentence. So by bringing this into play on top of the second-degree murder charge, the prosecution has ensured that if Curtis Reeves is convicted of second-degree murder, if the jury decides they don't buy his self-defense justification claim, he's not merely subject to a theoretical 30-year sentence or a theoretical life sentence with discretion by the judge to deliver a much lesser sentence than the maximum. He's going to serve a mandatory minimum of 25 years in jail. And the Florida courts have ruled that this provision will also apply to the aggravated battery charge against him for the firing of the bullet through the hand of Nicole Oulson. The Florida courts have ruled that if you're hit with multiple convictions to which this applies, the sentencing enhancement applies, those mandatory minimums cannot be served consecutively. They have to be served, they can't be served concurrently. They are served consecutively. So they stack upon each other. We'll look at the Nicole Oulson-based charge in just a moment, but it would also be a substantial mandatory minimum of 20 years, which means we'd have 25 plus 20, meaning 45 years mandatory minimum time in prison. Again, it's largely an academic matter with regards to Curtis Reeves, because any jail time is a life sentence. But theoretically, but for this provision, he could serve no time at all. That's off the table. He will go to prison if convicted because of the mandatory minimums required under 775087. So that is the Curtis Reeves criminal charge of second-degree murder for the shooting death of Chad Oulson. Now let's take a look at the aggravated battery charge based on the shot fired through the hand of Chad's wife, Nicole Oulson. She had her hand on her husband's chest, perhaps in an effort to physically restrain him. But when Curtis Reeves shot Chad Oulson in the chest, that bullet first passed through the hand of Nicole Oulson. Let's see. Let me just go through the comments real quick to see if there's any super chats I need to answer. Okay, not yet. So back to this information. So we have count 2 of the information then. This is the sworn document that brings Curtis Reeves into trial. We just talked about the second-degree murder charge for the killing of Chad Oulson. Now we're looking at the aggravated battery charge for based on the fact that the .380 caliber round that killed Chad Oulson first passed through the hand of Nicole Oulson's hand before it penetrated Chad Oulson's chest with fatal effect. So here the information reads, on the same day, of course, January 13th, 2014, These black squares, they've blacked out Nicole Oulson's name. I don't know why. There's no other person this could be, but that's in effect the what's blacked here. Nicole Oulson, the wife of Chad Oulson. So on that same day, Curtis Reeves did actually and intentionally touch or strike Nicole Oulson by shooting Nicole Oulson with a deadly weapon, to wit, a firearm, against the will of Nicole Oulson. So clearly she didn't consent to this touching, this battery. So that's the aggravated battery there. It's a battery committed with a weapon. And of course, the state again wants to bring in Florida's 1020 life sentencing enhancement law, so they have additional facts to support that. And during the commission of this offense, Curtis Judson Reeves, the defendant, actually possessed and discharged a firearm, and as a result of the discharge, great bodily harm or permanent disability or permanent disfigurement was inflicted upon any person. Well, it was inflicted on Nicole Oulson. She has permanent damage to her hand now as a result of the bullet that passed through it. And then the information references the relevant statutes here. So 784045, that's the aggravated battery statute. And then again, we see 775087, a different provision, 2A2, and then 775087, 2A3, which we already just looked at. But we'll take a look at this new provision, 775087 being the sentencing enhancement, of course. So this is the aggravated battery charge based on, premised on the shot fired through Nicole Oulson's hand. So let's take a look at the aggravated battery statute. So 784045, aggravated battery, and it had been under section 1A2, and it simply reads, a person commits aggravated battery. So battery, simple battery, is merely any unlawful, unconsented, offensive touching of another person. And that would be a simple battery. You just shoved somebody, for example. A battery not likely to cause death or serious bodily injury would be a simple battery. That simple battery, becomes aggravated under certain circumstances, one of which, if it's done to intentionally, knowingly cause great bodily harm, permanent disability, or permanent disfigurement. Curtis Reeves is not charged under that provision. He's charged under this one. A person commits aggravated battery who, in committing battery, meaning simple battery, uses a deadly weapon. Well, Curtis Reeves did that. I mean, this battery was committed with that .380 caliber pistol. Curtis Reeves will, of course, attempt to justify that as self-defense, in which case he would have zero criminal liability, but that's the argument that will be made at court. The criminal charges, the commission of a simple battery using a deadly weapon, becomes an aggravated battery. Then we look back at the sentencing enhancement provisions. One of those we already saw. That's 775087 2A3. That would get Curtis Reeves another mandatory minimum of 25 years. But there's another provision of that sentencing enhancement, 2A2, that could also apply. And that would be, let's see, pull that up. To A2, and it reads, any person who's convicted of a felony or an attempt to commit a felony listed in those enumerated lists, and both murder and aggravated battery are listed there, regardless of whether the use of a weapon is an element of the felony, and during the course of the commission of the felony, such person discharged a firearm, shall be sentenced to a minimum term of imprisonment of 20 years. So this provision, this one, also specified in the information against Curtis Reeves, would get him a mandatory minimum of 20 years in prison, no discretion by the judge, and it would stack on top of a conviction for the second-degree murder charge, which would already have gotten him a mandatory minimum of 25 years. So this is where we get the criminal charges and the sentencing enhancement. So Curtis Reeves, if convicted, is looking at a mandatory minimum of 45 years in prison. Again, he's 79 years old now, was 71 years at the time of the event. For a 79-year-old, really any prison time is a life sentence. But what the sentencing enhancement really does is not so much, the relevance is not so much the total time he would serve. He's obviously not going to live for 45 years in prison at the age of 79, but it takes off the table the possibility that he could be sentenced to no time at the discretion of the judge. Now let's consider the defenses that will be brought up here. Several have been mentioned by the defense in this case, including two of Florida's self-defense statutes. Let's see, I'll pull those up. There's the core Florida self-defense statute, which again has changed since this event, and Curtis Reeves is entitled to be tried on the version of with the version of the statute that existed at the time of these events. So I want to make that very clear, because if I saw even the court get confused about this yesterday. And if you're looking at the wrong statute, you're not asking the right legal question. And of course, then you won't get the right legal answer. So I'm going to share with you for discussion purposes. And by the way, at the Law of Self-Defense website, we have all these statutes. I'm showing you them. They're from our website, and they have the various versions listed there. So I won't step through all the variations because it would take too much time. It's more of an academic exercise. But if you wanted to understand how the statute changed in 2005 and 2014 and 2017 up to its present version, you can do that we have all that laid out at our website when you look at these statutes. So we have two self-defense statutes. Then we also have Florida's forcible felony statute, because one of the justifications for the use of deadly defensive force under Florida law is that you're using it to prevent a forcible felony. So if Curtis Reeves was using deadly defensive force to prevent a forcible felony, that would be legally justified under Florida law. And that's important because there's a quirk of Florida law that elevates what might have been a mere misdemeanor battery to a felony battery if the victim of the battery is 65 years of age or older. And Curtis Reeves was 65 years of age at the time of these events. So it's really apparently undisputed, for example, that Chad Oulson had at the very least grabbed Curtis Reeves' popcorn and thrown it back at him. Well, that's a battery. That's a simple battery. It's not a battery likely to cause death or serious bodily injury. Of course, Curtis Reeves also claims further violence by Chad Oulson that would potentially qualify as an aggravated battery. But even if you don't believe those further claims, certainly the popcorn was thrown. That would be a simple battery under Florida law. And if a simple battery is committed upon someone who's 65 years of age or older, that becomes a felony battery, which would be a forcible felony, and deadly defensive force is permitted against a forcible felony. So that's one of the arguments I expect the defense to make in this case to justify this shooting. So let's take a look first at Florida's core self-defense statute, which will be the foundation of the legal defense in this case. This is Florida Statute 776012. You see, I have a lot of notes through here. This is the version that became effective in 2014. Now, this shooting occurred in 2014, but the shooting occurred in January, and this version of 776012 became effective in June. So it's not this version of the statute that's going to apply in this trial. It's the earlier version. And here is the earlier version. This one came into effect 2005. Now, 2005 is an important year in Florida self-defense law because it's when Florida famously became a stand your ground state. So Florida did a general revamping of their self-defense statutes. They did away with the element of avoidance with a legal duty to retreat in otherwise lawful self-defense. So that made them a stand your ground state. They also, at the same time, adopted self-defense immunity as a kind of fast track, low cost, low time means to adjudicate self-defense without having to go to a full-blown trial if you were successful in getting the immunity. We know Curtis Reeves pursued this. Florida self-defense immunity statute has also undergone many revisions and modifications since it was adopted in 2005. But it was that year, 2005, that Florida became stand your ground, so did away with the legal duty to retreat in otherwise lawful cases of self-defense, and adopted self-defense immunity. Now, these are two completely different legal doctrines. Stand your ground and self-defense immunity are two completely different legal doctrines. They're found in different places in Florida statute. They're not the same things at all. Unfortunately, it's become commonplace, even by good attorneys in Florida and good judges in Florida, to use the phrase stand your ground to refer to both those things: the relief of the legal duty to retreat on the one hand and self-defense immunity on the other. So when a defendant like Curtis Reeves demands a self-defense immunity hearing, it's common to hear it referred to as a stand your ground hearing. That hearing has nothing to do with stand your ground. There is no such thing, really, as a hearing about stand your ground. Stand your ground simply applies to everybody. You don't need a hearing to qualify for it. When you hear that stand your ground hearing, what it really means is a self-defense immunity hearing. But in any case, both those things were adopted in 2005. So here's the version of Florida self-defense statute that was effective at the time that Curtis Reeves shot and killed Chad Oulson, fired that round through the hand of Nicole Oulson. So this is the statute that is relevant to this criminal trial. If you look up Florida statute 776012 today, you'll see this version. That's not the correct version for this trial. And the easiest way to tell the difference is this has a very lengthy paragraph 2. The older version simply has a one-sentence paragraph 2. But in any case, the relevant statute, the one that was in effect at the time of the shooting, reads: a person is justified in using force, except deadly force, against another when and to the extent that person reasonably believes that such conduct is necessary to defend himself or herself or another against the other's imminent use of unlawful force. So this is essentially the privilege for the use of non-deadly defensive force. If you want to use deadly defensive force, there are additional conditions that must be met. Those are specified here. However, a person is justified in the use of deadly force and does not have a duty to retreat. That's the stand your ground provision that was added in 2005. A person is justified in the use of deadly force and does not have a duty to retreat if he reasonably believes that such force is necessary to prevent imminent death or great bodily harm to himself or another, or to prevent the imminent commission of a forcible felony, or under those circumstances permitted under a different statute we'll look at as well, 776013, sequentially the next statute in Florida code after this one. Now, if we look through the statute, most of you will know that we teach self-defense law using a framework of the 5 elements of self-defense. If you're not familiar with those, folks, you should at least download our free infographic, the 5 elements of self-defense law infographic. It lists the 5 elements. They are innocence, imminence, proportionality, avoidance, and reasonableness. It provides a brief description of each of those 5 elements. If you don't understand these 5 elements, you can't possibly understand use of force law, because these are the building blocks of any claim of self-defense. So the good news is there's not 500 things you have to have in your claim of self-defense for it to be valid. There's not 50 elements of a self-defense claim. There's only 5, and there's only up to 5. Sometimes not even all 5 are required. They're not normally required under Florida law, all 5. For example, the element of avoidance deals with whether or not there's a legal duty to retreat. And as we just saw, Florida does not impose a generalized legal duty to retreat if you're acting in otherwise lawful self-defense. So under Florida law, in most circumstances, we're only dealing with 4 of the 5 elements. But you have to understand these 5 elements, folks. So you can get this infographic at lawofselfdefense.com/elements. It doesn't cost a penny. It's a PDF download, lawofselfdefense.com/elements. If you'd like a more thorough, plain English education on the 5 elements and how they work, you can get our free book, the softcover book. It's a real physical book, folks. We ship it to you, and so we have to ask you to pay for the shipping and handling, but the book itself is free. If you don't want to get it for free, you can order it from Amazon. I think it's $25 plus shipping and handling, or you can get it from us for free. Just pay the shipping and handling at lawofselfdefense.com/free book. This is couple hundred pages explaining the 5 elements of self-defense in plain English. Or if you prefer, you can get this very nice hardcover version of the book. This is at lawofselfdefense.com/gethard, the hardcover. This one's not free. We do ask you to pay for this because it's more costly to print, but it's also available. Looks great on the bookshelf. Makes a great gift, by the way, for Father's Day, that kind of thing. lawofselfdefense.com/gethard. All right, folks. So here's a self-defense statute. And what I'm going to do now is actually step through it and reveal the 5 elements, because it's not framed. It doesn't list 5 elements here. There is no self-defense law anywhere that explicitly lays out itself in these 5 elements. But once you know the 5 elements, you'll see them. You can find them in the self-defense law of every one of the 50 states. So before we do that, I see a couple super chats came in, so let me scroll through and address those now so I don't fall too far behind. And yes, folks, if you could hit the thumbs up, like button, and subscribe. You need to subscribe to comment. That's greatly appreciated on the YouTube view of all this. So Phil H., thank you for your super chat contribution. It's much appreciated. Phil writes, great work, Andrew. I'm interested in your thoughts on why it has taken 8 years to get to trial. Well, I don't know, so I have to speculate about that. There is, of course, a U.S. constitutional right to a speedy trial. So the state's not permitted to simply drag out a criminal trial endlessly. And as you might imagine, that provision of a right to a speedy trial is in our Constitution because that used to be done prior to our Constitution. Criminal charges would be brought and never brought to trial. So the defendant was always under a cloud. And so our founding fathers said, no, if you're going to charge someone, if the state is going to charge someone with a crime, they have to get it done. Bring your evidence, bring your arguments, either convict them or have them acquitted. But we're not going to allow you to endlessly, years at a time, keep a criminal defendant under this cloud of prosecution that never actually happens. So the defense has a privilege to a speedy trial. It's not uncommon, however, for defendants to waive that right. And you can waive that right like you can waive really any other right, right? You have a right to counsel. You have a right to silence. All kinds of rights in the Constitution. You can waive those rights. And it's not uncommon for defendants to waive rights, and for a variety of reasons. One, of course, is if the case against you is bad for you, good for the state, bad for the defendant, so that when you get to trial, you're likely to be convicted. Well, then you want as much delay as possible, right? Every year of delay is a year you're not yet convicted. Or it may be that you need more time yourself to pull together evidence, to pull together experts, maybe to raise money for a legal defense, so that a delay in the proceedings would be beneficial to you. Now, normally that's not the case. I mean, if you were a 25-year-old defendant, you don't want normally a prosecution to drag on for 10 years because it kind of puts your life on hold, right? I mean, what do you do if you're facing a serious charge like a killing charge, looking at the prospect of life in prison without possibility of early release if you're convicted? What do you do if you're waiting for trial for 8 years? Do you go to college and get a degree? Do you get married? Do you have kids? Do you buy a house? I mean, you're frozen, really, because for all you know, when you get to trial, you're going to be sentenced to life in prison. that dynamic doesn't really apply, of course, if you're in your 70s. If you're in your 70s, you want as much delay as possible. I mean, you're not making those kinds of critical life decisions anymore. In this case, Curtis Reeves was already retired at 71. Any prison sentence for him is a life sentence, in effect. So he wants as much delay as possible. So I expect that much of this delay was, not at the request of the defense, but certainly with the consent of the defense, that they saw it as advantageous. Every year that Curtis Reeves is not already convicted and in prison, and remember, he's looking at mandatory minimum sentences, so the prospect of no jail time is off the table. Every year they delay is a year their client's not in prison, and if they can delay enough, well, I mean, he's 79 now. I mean, if they delay enough, he dies without ever going to trial, in which case there is no trial. There is no conviction. There is no prison sentence. So certainly that's why the defense would want to delay. Why the state would allow it to be dragged out this long is less obvious to me, unless they really didn't want to convict him. They didn't want to try him. I mean, the state could have made a decision that, hey, listen, he's a retired cop. He's well respected in the community. This looks like an ambiguous case to us. It's not clearly murder. It's not like he killed his wife for money or something. There was a confrontation. The other guy was physically aggressive, much younger than him. It's not a great prosecution. And generally, prosecutors don't like to bring cases that aren't locks. I mean, most prosecutorial offices have conviction rates at trial of 90 to 95%. And that's because they only bring to trial the cases they're almost certain to win. They don't like to lose at trial. It's one of the reasons, I mean, our tagline is, if you carry a gun so you're hard to kill, know the law so you're hard to convict. Because and that doesn't mean learn legal tricks. It means know where the actual legal boundaries are for use of force, so that if you are compelled to defend yourself, you're so within the legal boundaries that you're literally hard to convict. Keep in mind, the state has to disprove self-defense beyond a reasonable doubt. That's a high burden. So if you can keep yourself well within the legal boundaries, that's very difficult. You give your defense lawyer good facts, you become hard to convict. And if you're hard to convict, if you appear to be hard to convict, you become a very unattractive target for prosecution. So in this case, the prosecutors might have thought, this is not a great case for us. It's not like it's a 95% likely to win case. It's more ambiguous than that. And if we do delay it long enough, this guy will die. And then we never have to take him to trial. So again, I've not spoken with any of the parties here, the defense or the state. So I don't know why it took 8 years, but those are some of the motivations I could imagine. Then there are, of course, some other kind of more legitimate, from a legal perspective, factors. So they had this self-defense immunity hearing in 2017. That was I think it was a full 10 days. So it was longer than most actual murder trials, the self-defense immunity hearing. So there would have been time to prep for that, just like you would prep for any 2-week trial. And then you have to have those proceedings and the judge has to make your decision. So that certainly takes time. Then, of course, the last couple of years we had COVID naturally. So that might account for 2 of the 8 years. But even if you take COVID off the table, it was a 6-year delay. The self-defense immunity hearing shouldn't contribute that much to a 6-year delay. So why it was otherwise delayed so long is difficult to understand, especially when the facts are really not that complicated or even disputed. I mean, they're disputed on the edges, but it's not like there's a tremendous amount of investigation that has to be done. So I don't know. I was writing about this case when it occurred in 2014 and touching back every couple of years when something interesting happened, and I was always befuddled by how long it was taking. And there was another super chat here. Warrior B _ Yacht. B Yacht. I get it. I see what you did there. Thank you for your super chat. That's much appreciated. Warrior B asks, have we determined the actual reason why he shot him? This is a bizarre story. We'll hear the reason because we're going to hear the opening arguments, maybe the closing arguments from the self-defense immunity hearing. The defense is not arguing that Curtis Reeves shot Chad Oulson because Chad threw popcorn at him. Of course, that's the hyperbole that the media reports. But the defense is that not only was the popcorn thrown, but then Chad Oulson struck Curtis Reeves in the head hard enough for Curtis Reeves to believe that Chad had an object in his hand at the time, maybe a cell phone, maybe something else. But that a blow to the head delivered by a 43-year-old male, which is the age of Chad Oulson at the time, a blow to the head of a 71-year-old is force likely to inflict death or serious bodily injury. And a pretty good indication that you're going to get hit a second time is that you got hit the first time. It's not like Chad hit him in the head and then walked away. He was still there. And it was to prevent an ongoing aggravated battery, a battery likely to cause death or serious bodily injury to an elderly victim, and also one that technically qualifies as a forcible felony under Florida law, based on the special provisions of Florida law we'll talk about in a moment, that Curtis Reeves fired that shot to prevent that deadly force attack upon him, and or forcible felony attack upon him. So that's the defense explanation for the firing of the shot, not merely popcorn. Jay Wolfenstein, thank you for your super chat. He asks, is there a free way for us to look up case law regarding a statute, or does that require some kind of legal subscription service? So most case law is freely available on the internet, but it's not very searchable in a productive way. So if you knew and by case law, folks, we mean appellate court decisions. So you have trial courts. Typically, you have a mid-level appellate court, and then you have a state Supreme Court. And it's the appellate courts, the mid-level appellate court and the Supreme Court. Their decisions have precedential value. They are controlling on the courts below them in that hierarchy. So you can imagine it like a pyramid. At the bottom of the pyramid, you have the trial courts. Their rulings are binding on nobody, but the participants in that particular trial. In fact, there are many cases where a trial judge makes a decision in his courtroom in a particular case, and the next day, in an essentially identical case, makes the opposite decision. I've seen cases where trial courts have made decisions, like an evidentiary decision, in a case involving a particular defendant. The defendant gets convicted, appeals, gets his conviction reversed, comes back for a retrial in front of that same judge, and that same judge with the same defendant, with the same facts, makes the opposite evidentiary decision. So trial court decisions and orders are not binding on anybody, really. I mean, they're binding on the parties in that moment, but they're not even binding on that particular court or that particular judge if he has to make a similar decision at a later time. So trial court orders and decisions have no precedential value. They're not controlling on anybody. Once you get to the mid-level appellate courts, they are reviewing convictions and other matters that happen at the trial level. Their rulings are controlling on the trial courts below them, often not controlling on the other mid-level appellate courts. There's usually many mid-level appellate courts, each in different districts of the state. And then once you get to above that, to the state Supreme Court, the state Supreme Court's decisions are, of course, binding on all the courts because they are at the top of the pyramid and all the courts are below them. So when we say case law, we're meaning those appellate court decisions. Those are the only ones that are really captured in any organized way, because those are the only ones that have any controlling impact on lower level courts. And those decisions are almost entirely now available on the internet, but not searchable. So if you knew the specific decision you were looking for, if you were looking for Tennessee versus Garner, for example, a U.S. Supreme Court police use of force case, it's quite famous. Google that, Tennessee versus Garner, it'll pop right up. But you would need to know what you were looking for beforehand. So if you want to do searches, the internet's not all that helpful for that, the free internet. Most law practices, my own law practice, has a subscription to a professional legal database. We use Lexis here. Westlaw is another common one. And those subscription services, which are expensive, we pay thousands of dollars a year for our Lexis account. They have very sophisticated search tools for searching for case law. So a normal person who's not a practicing lawyer wouldn't have their own account on Lexis or Westlaw, for example. But what you can do is, to my knowledge, all states have open access law libraries. Often they're across the street from a courthouse. And you can go to that law library and ask the clerk for assistance, or usually they have several computer terminals set up. And those computer terminals have Lexis or Westlaw access on them. And you can just sit at that terminal and they'll boot it up for you, log you into Lexis, and you can do your own searches there. So if you're a normal person who doesn't have your own Lexis account, I would find an open access law library. Every state, to my knowledge, has them, and just use their terminal, use their Lexis account to do your search. But I would think it would be very difficult to do any kind of productive search unless you were using a Lexis or Westlaw account. Phoenix, Lord Assurman, thank you for your very generous super chat. Much appreciated. He writes, I haven't had time to watch the streams on this so far, but I'm genuinely curious. Do you think Reeves has a shot at getting a not guilty for the popcorn event? It seems like an uphill battle. Well, if you believe he shot Chad Oulson simply over popcorn, maybe it's an uphill battle. And if all you hear about this case is the media reports, that might be what you think. Because that's all you're hearing. But again, the defense is not arguing that Curtis Reeves shot Chad Oulson over popcorn. They're arguing that Chad Oulson struck Curtis Reeves, 43-year-old Chad Oulson, lunged at and struck Curtis Reeves in the head with an object with sufficient force to have a reasonable likelihood of causing death or serious bodily injury. That's a deadly force attack against which deadly defensive force is authorized under Florida law. Also, that attack would qualify as a forcible felony, even if it didn't inherently threaten deadly force. It would still qualify, arguably, as a forcible felony under Florida law. And again, deadly defensive force is authorized to prevent forcible felonies under Florida law. So yes, there are sound legal arguments to be made here to justify the shooting death of Chad Oulson as lawful self-defense. What it really comes down to is which version of the facts do you believe? Do you find credible? Do you believe that Chad Oulson struck Curtis Reeves forcefully in the head? If he did, a blow to the head by someone in close proximity, especially with this age disparity, this fitness disparity, it could well be a deadly force attack against which deadly defensive force is justified. The more technical argument I find less compelling is this forcible felony argument. But again, we have to ask ourselves how sympathetic a Florida jury might be to that argument. Florida has a lot of elderly people. There's no doubt that a 43-year-old man attacking a 71-year-old has a substantive physical advantage, represents a greater threat of harm. The 71-year-old is more vulnerable than they would be if they were themselves 43 years of age. So all that comes into play. And keep in mind that the prosecution has to disprove this claim of self-defense beyond a reasonable doubt. So that's a very high threshold for the defense, for the state, rather. When the state was successful at the self-defense immunity hearing, there the state only had to overcome self-defense by 51% of the evidence, and only to the satisfaction of the judge. There was no jury there. Here at trial, the state has to overcome self-defense beyond any reasonable doubt. That's not 51%. That's more like 90% or 95% of the evidence. And they have to convince the jury of that unanimously, all 6 members. So a much higher burden for the state at this trial than it was at the self-defense immunity hearing. That said, of course, the risk of conviction at trial is never zero. It's always something more than zero. So certainly possible that Curtis Reeves could be convicted. Let's see. Scrolling through the comments quickly before we dive into this self-defense statute and pull out the 5 elements of self-defense. All right, so here's the statute. It's up on the screen. It's not very long. And of course, we teach self-defense law in terms of the 5 elements of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. Innocence, meaning that you were the victim of someone else's aggression. You were not yourself the initial aggressor. You were not a mutual combatant. You were not a provoker with intent. The other guy was the initial physical aggressor who you did not provoke. That's the element of innocence. That has to be present in your claim of self-defense. The element of imminence means that the threat you were defending against was either in progress or immediately about to occur. It wasn't a past threat, and it wasn't some speculative future threat. It was an imminent threat. Also a required element of self-defense. Proportionality has to do with the degree of force involved in the confrontation. There's really 2 buckets of force. There's non-deadly force on the one hand and deadly force on the other. Deadly force meaning force reasonably likely to cause death or serious bodily injury. Serious bodily injury, I believe Florida uses the phrase grave bodily injury, refers to a non-minor injury or broken bone, disfigurement, loss of a bodily function, a maiming type injury. Avoidance is the element that's not normally applied in a stand your ground state like Florida in cases of otherwise lawful self-defense. So avoidance applies in about, I believe it's 11 states now still impose a generalized legal duty to retreat. In those states, if you have a safe avenue of retreat, you're required to take advantage of that before you can act in lawful self-defense. Most states do not impose a generalized legal duty to retreat in otherwise lawful cases of self-defense, and Florida does not. So in Florida, there is no generalized legal duty to retreat. So in otherwise lawful cases of self-defense, there is no element of avoidance required. Now, avoidance can be brought back in under Florida law in certain facts. If you're in a place you don't have a right to be, if you're engaged in unlawful activity, if you were a provoker of the confrontation, which has a very specific legal meaning, then you can reacquire that legal duty to retreat. But in otherwise lawful cases of self-defense, where those exclusions are not triggered, you don't have the element of avoidance. And finally, reasonableness. So the element of reasonableness requires, really there's 2 facets of it, subjective reasonableness and objective reasonableness. Subjectively, you have to have had a genuine good faith belief in your head in the need to act in self-defense. But that belief by itself is not sufficient. That subjective, genuine good faith belief also has to be objectively reasonable. A hypothetical, reasonable, and prudent person in your situation would also have shared that subjective belief. So that's the element of reasonableness. So innocence, imminence, proportionality, avoidance, and reasonableness. And if we look through this Florida statute, we find all those 5 elements. So a person is justified in using force except deadly force. So this is touching upon the element of proportionality, that there's 2 buckets, non-deadly force and deadly force. And that applies in terms of the threat you're facing. Is it a non-deadly force threat or a deadly force threat? And it also applies to the defensive force you're using. Are you using non-deadly defensive force or deadly defensive force? And that's what proportionality means, that your defensive force has to be proportional to the aggressive force. So if you're only facing a non-deadly force threat, you can only use non-deadly force in self-defense. If you're facing a deadly force threat, then you're privileged to use deadly force in self-defense. That's the concept of proportionality. And how most states treat this in their law is they'll set forth the conditions that are required to first be justified in using any force at all, meaning non-deadly force. So certain conditions have to be met before you can lawfully use non-deadly force upon another person. And then they add additional conditions that have to be met before you're privileged to use deadly force against another person and have it be justified as lawful self-defense. And we see that here in this Florida statute. So this first paragraph, first sentence, sets out the conditions for non-deadly force. They don't call it non-deadly. They call it except deadly force, but that's what they mean. These are the conditions for non-deadly force. And then the remainder of the statute sets forth the additional conditions that have to be met before deadly defensive force can be used. So this is the element of proportionality, this non-deadly versus deadly force. So that's one of the 5 elements, proportionality. So we continue reading. So except deadly force against another when and to the extent the person reasonably believes. This is the element of reasonableness, folks. So you have to actually believe, you have to have the subjective belief, and that subjective belief has to be reasonable. And folks, when you look at any self-defense law, you'll see this reasonableness element everywhere. Often it's mentioned multiple times in single sentences. We see it's mentioned twice here in the statute, right? Because it's mentioned again in subparagraph 3. And that reflects the weight and importance that the law puts on this element of reasonableness for self-defense law purposes. So here we already had proportionality. Now we have the element of reasonableness. So the person reasonably believes that such conduct is necessary to defend himself or herself or another. So this is a defense of self and a defense of others statute. Defend himself or herself or another against the other's imminent use of unlawful force. So there's the element of imminence. And that you're defending against an unlawful force is the element of innocence, that the other person is acting unlawfully. You're not resisting a lawful arrest by a police officer, for example. That would be a lawful use of force upon you. You can't resist that and call it self-defense. So you need to be the innocent party, that you're defending against an unlawful force. That's the element of innocence in the Florida self-defense statute. So we've had proportionality, we've had reasonableness, we have imminence. It continues. However, a person is justified in the use of deadly force, again, proportionality, and does not have a duty to retreat. That's that element of avoidance being taken off the table. And this is what these specific words were what was added in 2005 that made Florida a stand your ground state. You do not have a generalized legal duty to retreat in otherwise lawful cases of self-defense. So it continues. You can use deadly force and do not have a duty to retreat. And you never had a duty to retreat if you were only using non-deadly force. That never existed. The duty to retreat is normally applied only, if it's applied at all, applied only in a deadly defensive force scenario. So this is the deadly force portion of the statute. A person is justified in the use of deadly force and does not have a duty to retreat if. And now we're getting to the additional conditions that have to be met before deadly defensive force can be used. You have to reasonably believe the force is necessary to prevent imminent death or great bodily harm. So death or great bodily harm is the legal definition of deadly force. So before you can use deadly defensive force, you have to be facing a deadly force threat, imminent death or great bodily harm, or to prevent the commission of a forcible felony. So there's already here 2 separate bases for being justified in the use of deadly defensive force. One is you're facing a deadly force threat. The second is you're facing a forcible felony threat. Now, normally, these work out to the same things because most forcible felonies, and we'll look at the Florida statute that defines forcible felony. It enumerates a bunch of felonies, all of which really have force baked into the cake. Things like deadly force baked into the cake. So like aggravated assault, aggravated battery, that's a deadly force assault, a deadly force battery, hijacking, piracy of aircraft. They're all, the enumerated list is all things that really have deadly aggressive force baked into them. Although it does end as a kind of a catch-all, or any force being used against another person unlawfully. And of course, we have that other provision, a separate Florida statute that makes a non-deadly battery of a person 65 years of age or older, makes that a felony. So that would become a forcible felony as a legal technicality, even though the actual degree of force involved was not deadly in nature. So that will be, certainly, I would expect, a legal argument by the defense in this case. But in order to be justified in using deadly defensive force, you have to be preventing imminent death or great bodily harm, or preventing a forcible felony, or Yet a third provision of Florida law that justifies the use of deadly defensive force if you're using that deadly defensive force under the circumstances permitted by the next statute, 776013. So we'll take a look at 776013 in a moment. But first, I just want to refresh everyone's collection. These 5 elements of self-defense, get this infographic, folks. It doesn't cost a penny. lawofselfdefense.com/elements provides a brief description of the 5 elements of a claim of self-defense: innocence, imminence, proportionality, avoidance, and reasonableness. And as you can see, they are all present, or at least addressed, in this Florida self-defense statute, 776012. If you look at the self-defense law of your state, you will also find these 5 elements addressed. Now, they may not all apply. Like avoidance doesn't apply here because Florida's taken avoidance off the table in otherwise lawful cases of self-defense. And there are other circumstances in which, in effect, more of those 5 elements are waived or presumed to be present. We'll see that in the next statute, 776013, where the state effectively says, the law says, hey, under these circumstances, we're going to presume that as many as 4 of the 5 elements, we're going to presume they're present. So those are effectively taken off the table. When they're not taken off the table, however many of the elements are still on the table, have not been legally waived or presumed, those elements are cumulative. They are required. So if all 5 elements are required, folks, you have to have all 5. If any one of them, any one required element is disproven beyond a reasonable doubt by the state, your claim of self-defense isn't just weakened, it's obliterated. It was not self-defense. It technically cannot be self-defense as a legal matter if one of the required elements is missing. So another way to look at that is every element that is required is a target of attack by the prosecutor. The prosecutor knows which elements are required, and he knows if he can disprove any one of them, not all of them. He doesn't have to disprove all of them. If he can disprove any one of them beyond a reasonable doubt, your claim of self-defense collapses. And in a self-defense case, that's very bad news because self-defense is inherently a legal defense of confession and avoidance. You're not saying it wasn't me. I didn't shoot that guy. Curtis Reeves here is not denying that he shot Chad Oulson. He's doing the opposite of that. He's saying it was me. I did it. I shot that guy and killed him. But I had the legal defense of self-defense. Well, if the prosecution can disprove one of those 5 elements and your claim of self-defense collapses, what's left of the confession and avoidance? Just the confession. So off to jail you go. Everybody knows this in that courtroom. The prosecution knows exactly what it needs to do. It needs to disprove any one of those elements beyond a reasonable doubt. So avoidance is off the table unless the prosecution can argue it should be brought back in. But whatever elements are required, and at the very least, innocence, imminence, proportionality, and reasonableness will be required if those are the attack points for this prosecutor in this case. So to the extent that the state waives or presumes more elements to be present, it effectively is taking targets of attack for the prosecution off the table. It's limiting the prosecution's opportunities for blowing up that claim of self-defense. So that's good for the defendant. And that's really what stand your ground does, by the way, folks. It takes one of the 5 elements off the table as a target of attack by the prosecution. If avoidance is required as a generalized legal duty to retreat, well, then it's a target of attack. If the prosecution can prove that you had a safe avenue of retreat and didn't take advantage of it, prove it to the satisfaction of the jury beyond a reasonable doubt, well, then you lose the element of avoidance. If it's required, you lose self-defense because you've lost that required element. Super chat here, Invictin. Thank you very much, Invictin. I much appreciate that. Asks, do you have any idea why the defense didn't apply for a 12-person jury? Well, the defense is not privileged to a 12-person jury in Florida on these charges. So you only have a right to a 12-person jury if you've been charged with murder in the first degree, which is really a capital offense. So if you're charged with a capital crime in Florida, you get a 12-person jury. Anything less than that, and it's a 6-person jury, even for felonies. Any felony less than capital murder. And Curtis Reeves was not charged with capital murder in this case. He's charged with second-degree murder and aggravated battery. And for both of those, you only get a 6-person jury. So there's 6 jurors plus 4 alternates, which is a pretty substantial number of alternates, really. But in any case, at the end, when the jury goes into the deliberations, the alternates will be dismissed, and it will be 6 jurors that hopefully arrive at a verdict. All right, so this is 776012, and you see those 5 elements of self-defense in here: innocence, imminence, proportionality, avoidance is taken off the table in otherwise lawful cases of self-defense, and reasonableness, all here. And it provides 3 bases for the use of deadly defensive force. One is to prevent imminent death or great bodily harm. Another is to prevent a forcible felony, or under the circumstances permitted. Something weird just happened. There we go. Permitted under a separate statute, 776013. So let's take a look at 776013. And this is all prep for the trial, which starts tomorrow, folks. So the trial will start tomorrow morning, 9 a.m. with opening statements by the state and the defense, and then we'll roll into the state presenting its case in chief and calling its first witnesses. That's 9 a.m. Eastern time, unfortunately. 7 a.m. my time. Adjust for your particular local time zone. So let's take a look at that next statute, which is 776013. And this is really mostly, not entirely, but it's mostly a defense of highly defensible property statute. Again, this statute also has undergone several versions over the years, starting with, it was first enacted initially, it came into existence in 2005 when Florida became a stand your ground state and adopted self-defense immunity. It also adopted this very special provision for the defense of highly defensible property. Highly defensible property in Florida law means a dwelling, a residence, or an occupied vehicle. So you have all your normal privilege of self-defense in those environments, plus they give you these special provisions, favorable provisions for the defendant, for the defender, if the defender is defending in the context of highly defensible property, residence, dwelling, or occupied motor vehicle. This was enacted in 2005 and has undergone several versions. It has there's a 2005 version, then it was modified in 2017, and let's see if there's even an earlier version. Yeah, the original 2005 version, the one that was in effect when Curtis Reeves shot Chad Oulson, is this version here that we're looking at. And mostly what this statute does is create a legal presumption that a defender defending against an intruder into highly defensible property, defending against an intruder into residence, dwelling, occupied motor vehicle, creates a legal presumption that that defender had a reasonable fear of imminent deadly force harm. And if you listen to those words, it's really giving the defendant, creating a legal presumption for several of the 5 elements of self-defense. It's creating a presumption that the defender had a reasonable fear of imminent deadly force harm. Well, reasonable fear is the element of reasonableness. Imminent threat is the element of imminence. Deadly force harm is the element of proportionality. So the legal presumption is giving you reasonableness, imminence, and proportionality. You already have avoidance because the Castle Doctrine would apply in these circumstances. So that's 4 of the 5 elements of self-defense that are given to you. The only element not specified here is innocence, but if you're defending against a forcible, unlawful intruder into your residence, dwelling, or motor vehicle, innocence is kind of baked into the cake. So this is a very favorable statute for a defender who is defending themselves in the context of highly defensible property, their residence, dwelling, or motor vehicle. None of that applies to this trial because Curtis Reeves was not in his residence, dwelling, or motor vehicle. So the vast majority of the statute that touches upon those special provisions, that presumption of a reasonable fear of deadly imminent force harm, um, doesn't apply to Curtis Reeves. So we're just going to skim over those. There is a provision, one paragraph of this lengthy statute that would apply to the Curtis Reeves facts, and it holds that a person who's not engaged in unlawful activity and who is attacked in a place they have a right to be has no duty to retreat. So this is more stand your ground language. By the way, there's no stand your ground statute under Florida law. So there's no single statute with a number that says there's no duty to retreat. When Florida adopted stand your ground, it just inserted this no duty to retreat language in its existing self-defense law. There is, on the other hand, an explicit self-defense immunity statute with its own number that stands alone. Just another indication that stand your ground and self-defense immunity are two different things. But here, this reinforces that there is no legal duty to retreat and has the right to stand his ground and meet force with force, including deadly force, if he reasonably believes it's necessary to prevent death or great bodily harm to himself or another, or to prevent the commission of a forcible felony. So here it's really just echoing the 776012 language that we just looked at in the previous statute. And then it defines what qualifies as highly defensible property under Florida law. So somebody had asked about the Super Bowl. So folks, I'm a terrible sports fan. I rarely watch sports at all, professional sports at least at all. And when I do watch, it's only because my local team happens to be having an exceptional year. Having lived in Boston, there were quite a lot of years like that when the Red Sox were dominant, or particularly when the Patriots were dominant. So I would watch occasional games. And of course, during those dominant years, it was Tom Brady, who was the Patriots quarterback. He left for the Buccaneers, won the Super Bowl again with the Buccaneers last year. So I did watch that Super Bowl with some interest because I appreciate watching Tom Brady play. Similarly, when the Chicago Bulls had Michael Jordan, I would watch at least the playoff games and the finals games with that had Michael Jordan in them, because I liked watching a truly world-class, exceptional athlete perform. But if it's just an ordinary game that doesn't have that particular point of interest for me, I generally don't watch. I would not be watching the Super Bowl, for example, once the Buccaneers and Tom Brady lost in the playoffs. My interest in this year's Super Bowl went to zero. But my wife has obligated me to go to a Super Bowl party, so I'll be at the party and the game will be on the screen. So I guess to that extent, I'll be watching the game. But I have no personal interest or care really for who wins. I don't know anything about the Rams or the Bengals at all. But yeah, I'll be watching, eating chicken wings and doing that other football type stuff, I guess. So what's the weakest point here for the prosecutor to attack? So the points of attack are those 5 elements of self-defense, right? Innocence, imminence, proportionality, avoidance, and reasonableness. I think the prosecution will attack all 5 of those points. I think he'll attack innocence by trying to argue that Curtis Reeves was a mutual combatant, or perhaps a provoker with intent, that he knew he wanted to shoot Chad Oulson, but wanted to get Chad Oulson to take the first swing. That whole punch me, I dare you, take your swing. Remember those guys by the dumpster, that kind of dynamic. And by the way, if the prosecutor can convince the jury that Curtis Reeves was a provoker with intent, that would bring the element of avoidance back in. Because as a provoker with intent, you lose the element of innocence, you lose self-defense, unless you withdraw from the fight and communicate your withdrawal to the other party. That's effectively a reacquisition of the legal duty to retreat, even in a stand your ground state like Florida. So the prosecutor can attack innocence in several ways: mutual combatant or provoker with intent. If he does the provoker with intent, that also brings back avoidance as an element that can be attacked by the prosecutor, even though Florida is otherwise a stand your ground state. He can attack the element of imminence by arguing that even if Chad Oulson had initiated and carried out some act of violence upon Curtis Reeves, that was over. He threw the popcorn, that was it. Maybe he even slapped him in the head, but that was it. The fight was over, and there was no justification to shoot him after that. Then it becomes a judgment call on whether you believe that's true. Was the fight over? Or did Curtis Reeves have a reasonable perception that this was a fight that would be ongoing, against which he could defend himself? It's not like there was a big pause in the action. Curtis Reeves fired his shot quickly after he was purportedly struck by Chad Oulson. So it's not like there was a 5-minute delay before the shot was fired. But nevertheless, that's an argument I would expect the prosecution to make. That argument on the element of imminence, that there was no longer an imminent threat, that the window of imminence had closed. Then we have the element of proportionality. And there I would expect the argument to attack proportionality by arguing that even if there was a threat facing Curtis Reeves, an imminent threat by Chad Oulson, it was not a threat likely to cause death or serious bodily injury. And if it wasn't, then Curtis Reeves didn't have the necessary justification for the use of deadly defensive force. His use of deadly defensive force was disproportional, and therefore he loses the element of proportionality. He loses self-defense. Avoidance, we already talked about, normally would not be an element in Florida, but if the prosecution can argue provocation with intent or even mutual combat, then avoidance would come back into play as a target for attack by the prosecutor. And then, of course, is the element of reasonableness. And this could, remember, there's two facets of reasonableness. Both are required. The prosecution could argue that it's not credible that Curtis Reeves had a genuine subjective belief that he was facing a deadly force threat, arguing perhaps that no one would subjectively believe that popcorn was a deadly force threat. Or if he did subjectively believe that his belief was irrational, that a hypothetical, reasonable, and prudent person in Curtis Reeves' position would not have had that subjective belief, and therefore you fail either the subjective reasonableness or the objective reasonableness. In either case, you fail reasonableness, and therefore you lose self-defense. So those are the attacks I would expect the prosecution to deliver. Which are strongest? I mean, you kind of have to hear the evidence and then hear the delivery of the arguments. And a lot of it will depend on the credibility, of course, of Curtis Reeves, who we're told, will be testifying in his own defense, did testify at length for 2 or 3 hours in his self-defense immunity hearing. Now, keep in mind, all that now is on the record. So whatever Curtis Reeves is going to testify about at trial, it has to be the same. Well, if it's not the same, if it includes substance that was not said in the self-defense immunity trial, he'd be subject to impeachment by the prosecution. What, you're saying this now, but you didn't say this then? Or you're saying this now and you said the opposite then? So one of the risks of a self-defense immunity trial is if you testify at it, and you pretty much have to testify at your immunity hearing, self-defense immunity hearing, I should have called it. It's like a mini trial, but it's not a full-blown trial. It's a hearing. If you testify there, you're locking yourself into whatever that testimony there was. So you don't get to later modify your testimony and have it appear credible, because it'll be impeached by the prosecution using the transcripts of your self-defense immunity hearing testimony. All right, so that's 776012, Florida's core self-defense statute, and 776013, which is largely this presumption of reasonable fear statute in the context of highly defensible property, but does have that one paragraph that echoes the language of 776012, the 5 elements of self-defense. But there are a couple of other relevant statutes here. So one of the grounds to justify the use of deadly defensive force is if you're defending against a forcible felony. So let's take a look at Florida's forcible felony statute. Here that is. So forcible felony means treason, murder, manslaughter, sexual battery, carjacking, home invasion robbery, burglary, arson, kidnapping, aggravated battery, aggravated assault, aggravated stalking, aircraft piracy, unlawful throwing, placing, or discharging of a destructive device, or bomb, and any other felony which involves the use or threat of physical force or violence against an individual. So you have this enumerated list of felonies that are defined here as forcible felonies, and then you have this catch-all at the end. Any other felony which involves the use or threat of physical force. So if any of this was occurring to Curtis Reeves at the hands of Chad Oulson, well, then Curtis Reeves was the victim of a forcible felony by Chad Oulson. And a forcible felony is a justification for the use of deadly defensive force by Curtis Reeves against Chad Oulson. Hey, C. Goody is here as a moderator. Thanks you, C. Goody. And I see he mentioned a bundle. So we've put together a bundle of our 4 best-selling courses. We did this for the Rittenhouse trial as well. We're doing it for this one. We're calling this one our popcorn bundle. But basically, it's our 4 best-selling courses. It's our 8-hour plus Law of Self-Defense Advanced course. That's the same course I teach in person. Teach it as continuing legal education for lawyers, judges, police officers, but it is taught in plain English. It's perfectly suitable for everybody. That course, that advanced course by itself, is normally $200 by itself. But with this bundle, if you get that course for $200, we throw in another $300 worth of courses at no additional cost. Those are our defense of property course, our law of self-defense state-specific supplement course. So you pick whichever state you want, and you get the self-defense law, the statutes, jury instructions, case law, on use of force law for that particular state. So that's a supplement to the 8-hour core class. And you get our defense against rioters, looters, and arsonists course. Each of those 3 courses is normally $100 each. So collectively, these 4 courses would be $500. But if you get the Law of Self-Defense Advanced course as this bundle, you get the advanced course, $200, plus those additional $300 worth of courses, state supplement, defense of property, and defense against rioters, looters, and arsonists for no additional cost. And these are all instant access online streamed courses. So if you'd like to learn more about that, you can see it in my image here. lawofselfdefense.com/bundle will get you more information on this popcorn bundle of our 4 most popular courses, 60% off, save $300. But as you might imagine, this popcorn bundle is available only during this trial. So when the trial is over, it goes back up to the normal price of $500. So that's at lawselfdefense.com/bundle. All right. So we were just talking about a second basis for the lawful use of deadly defensive force, the shooting of Chad Oulson by Curtis Reeves, would be if Chad Oulson was subjecting Curtis Reeves to a forcible felony. And Curtis Reeves is making this argument. He's making the argument that Chad Oulson struck Curtis Reeves, 43-year-old Chad Oulson struck 71-year-old Curtis Reeves in the head with an object sufficient to create a reasonable fear that Curtis Reeves was facing an imminent threat of death or serious bodily injury, grave bodily harm in the Florida parlance. And, an object brought to strike the head certainly can result in grave bodily harm. Above and beyond that, however, there's also the technical matter of whether or not Chad Oulson may have been technically committing a felony upon Curtis Reeves, even if Chad's use of force was not inherently deadly in nature. And that's a special statute that Florida has that escalates what would be a mere simple battery, a non-deadly force battery, a non-deadly force touching of another, to a felony if the victim of the battery is 65 years of age or older. So let's take a look at that. 1 second, folks. All right. Just wanted to refresh my coffee. Oh, the mug. The mug reads, lawyers because people are idiots. Different mug today, folks. So let's take a look at that special provision of Florida law about the victim of a battery being 65 years of age or older. So this is statute 78408. Assault or battery on persons 65 years of age or older. And the relevant statute is relevant section is a section 2. Whenever a person is charged with committing an assault or aggravated assault or a battery or aggravated battery, for our purposes, we're just going to focus on the battery. Chad Oulson's throwing of popcorn at Curtis Reeves was a simple battery. There's no question about that. But a simple battery is normally a battery not likely to cause death or grave bodily harm. It would not justify Curtis Reeves' use of deadly defensive force until we get to this provision. So whenever a person is charged with committing a battery upon a person 65 years of age or older, regardless of whether he knows the age of the victim, the offense for which the person is charged will be reclassified as follows. And in the case of a battery, a simple battery, it's reclassified from a misdemeanor to a felony. So Chad Oulson throwing the popcorn is not inherently a deadly force attack against which deadly defensive force would be authorized. But it is a simple battery. And Curtis Reeves was over the age of 65. He was 71 years old at the time this event occurred. Doesn't matter that Chad Oulson would not have known his age. But Curtis Reeves was over the age of 65. That simple battery then gets reclassified from a misdemeanor to a felony. And if it's a felony, well, it's involves force. Battery is a force. Then it's a forcible felony. And a forcible felony is a justification for the use of deadly defensive force under Florida law. And I would expect this to be an argument that the defense makes as an alternative justification for why Curtis Reeves was justified in using deadly defensive force. Now, it won't be their only justification. Again, they're arguing that Chad Oulson did use deadly force likely to cause grave bodily harm upon Curtis Reeves. And they have that justification for the use of deadly force, deadly defensive force. But on top of that, even if it wasn't a deadly force attack, inherently, it becomes a forcible felony under the provision of 74808. And therefore, it's a forcible felony against which Curtis Reeves would be justified under Florida law to use deadly defensive force. And of course, the judge will instruct the jury that they are to apply the law as the judge instructs them, even if they don't like the law or think the law should be different. So the jury will be told, in effect, listen, even if you think it's ridiculous that someone could be justified for shooting dead a person who merely throws popcorn at them, if these facts are true, and the throwing of the popcorn is really undisputed, that's a forcible felony under Florida law. Now, the weaknesses to this particular argument are, well, first of all, it does seem ridiculous, right, on the merits. And juries don't always apply the law as they're instructed to do it. So there's that risk. But there are more substantive risks, and that is, first of all, if I were the state, I would argue that, look, this paragraph 2 says, when a person is charged with committing a battery upon a person 65 years of age or older, you have this consequence, right? The battery is reclassified from a misdemeanor to a felony. But nobody was charged with a battery here. Or rather, Chad Oulson was not charged with the battery for the obvious reason that he was dead. You don't charge dead people with crimes. But he, strictly speaking, was not charged. So if he was not charged with the battery, then this effect does not happen. This escalation does not happen. Secondly, if I were the state, I would argue that the legislature's intent here was not to privilege the use of deadly defensive force in these circumstances where you're facing only a simple battery, that this was merely a sentencing enhancement for the person that committed the battery, that it ought not have any effect on legal privileges of anybody else. This applied only to the person who committed the battery, was charged with the battery. Their offense gets escalated for sentencing purposes. It does not change the existing self-defense privilege for some other party. So those are the two arguments I would make here if I were the defense. Let's see. Yeah, plain piracy sounds bad. That's one of the listed forcible felonies. It's because of hijackings, folks. And, there was a time in American history back in the 60s and 70s where aircraft hijacking, commercial plane hijackings were not that unusual. And Florida, of course, is a tourist mecca, and Florida would like to not have its tourists discouraged from coming to Disney and the beaches and elsewhere because they had a fear of hijacking. So if someone were to attempt or commit aircraft piracy, that would be a forcible felony, and they could be subject to deadly defensive force. Let's see. Yeah, I see that someone had a question about whether we only cover like guns in our courses of instruction or in our books. We don't, folks. We're very agnostic about the manner in which defensive force is used in our books, in our courses, everywhere. When we cover these trials, the trials usually involve guns or some other deadly weapon. Our trial coverage tends to be weapon specific based on the facts of that particular case. But really, use of force law doesn't care about particular weapons. The core of use of force law, those 5 elements, it cares a lot about the intensity of force involved, whether it's deadly force or non-deadly force. That's that element of proportionality. But if you're in the deadly force bucket, the law doesn't particularly care what you're doing there. If it's deadly force, it's deadly force. And that could be by means of a weapon designed, intended to inflict death or grave bodily harm, like a gun or a knife. But it could be any object. If the object is being used in a manner likely to cause death or grave bodily injury, then you're in the deadly force bucket. It's deadly force. So a gun, a knife, a bat being used to play baseball is not being used to inflict deadly force. But if it's being used to strike someone in the head, that baseball bat, a toy, under normal circumstances, is certainly a deadly weapon. A plastic shopping bag carrying groceries, not a problem. But if it's put over someone's head to asphyxiate them, it's inflicting deadly force harm. A pillow with a kitten embroidered on it, not something you would think of as a deadly weapon, but if it's being used to smother somebody, yeah, it's being used to inflict death or grave bodily harm. So we don't really care about the weapon per se, except on the margins, because as we saw in this case, if you use a gun in Florida, then you're subject to certain very grievous sentencing enhancements that wouldn't arise if you'd used a knife or the plastic shopping bag or the pillow with the kitten on it. None of that would come into play. The sentencing enhancement would not come into play under those circumstances. It requires a gun. But in terms of whether or not the underlying use of force was lawful or not, defensive force was lawful or not, the law doesn't really care how you inflict the deadly force. You could use your car to run somebody over. You could drop a piano off a building onto somebody's head. There's an active shooter in the street and you happen to be on the roof of the piano. That's fine. If you're justified in using deadly force on that person, you're justified regardless of the nature of the deadly force you're using. What the law does care about is whether or not you are justified in deadly force in the first place. So do you meet the conditions? If you meet the conditions, the law doesn't much care what the means is. Yeah, if you could hit the thumbs up button, folks, that would be appreciated. You think we've earned it. And also, of course, the subscribe button. So those are all the statutes I wanted to cover relevant to this case. So the criminal statutes for second-degree murder, for aggravated battery, the aggravated battery being that the bullet passed through Nicole Oulson's hand before it killed Chad Oulson. She had her hand on her husband's chest, presumably in an effort to physically restrain him, which, that's not a good fact for the state. That's a pretty good fact for the defense. And when Curtis Reeves fired that .380 caliber bullet, it first went through her hand on her husband's chest before it struck him with fatal effect. A little 380, folks. 380s kill a lot of people. Most folks in the gun community kind of look down on 380s. They are, handgun calibers in general are not terribly effective most of the time. Even 40 caliber, 9mm caliber, and a 380 is basically a short 9mm, a weak 9mm. But lots and lots of people get killed with 380s, folks. A lot of bad guys carry 380s because they're cheap, inexpensive guns. Many of them are. There are, of course, some more costly 380s. And lots of people get shot with 380s, and lots of people get killed with 380s. And obviously, it's mostly about shot placement. Chad Oulson got shot in a fatal place by that 380 round, and it killed him dead right there. All right, so C. Goody asks, is the Miranda stream that was removed yesterday going to still happen, or has that been postponed indefinitely? So I had planned to do a very lengthy, really kind of a course of instruction live yesterday on Miranda rights. I would still like to do that, but it's a pretty complicated topic to cover in the depth I would like to cover it. And we had some other family stuff happening, and I just didn't have the time to build it out to the degree that I wanted. So we mentally canceled that class. We forgot to cancel it on YouTube, unfortunately, until after people began to show up. My apologies for that. We just dropped the ball on that. I imagine I will do the Miranda thing, but not soon. This trial starts tomorrow morning. We'll be covering the trial live. So those will be full days for the duration of the trial. And soon after the trial's over, I'll be leaving on my motorcycle trip to Texas Hill Country, and I'll be riding a motorcycle all day for the next week or week and a half. So I expect it'll be at least a month before we circle back to that Miranda course of instruction that we have tentatively planned. Let's see. Yeah, I wasn't being late yesterday morning, folks. We just forgot to cancel the class. So I do have now the video of the defense and the prosecution opening statements at the self-defense immunity hearing, and I expect those opening statements will be largely mirrored tomorrow morning. So I think it would be useful to listen to them set out their case in chief. Now, an interesting facet of this, because these earlier opening statements happened at the self-defense immunity hearing, the order in which we hear the opening statements is the reverse of the normal. So normally in the trial, tomorrow morning, for example, the state will give its opening statement first, and then the defense will give its opening statement. And of course, the purpose of the opening statement is to kind of frame out your narrative. You're telling the jury, these are the things we will show you. There'll be some discussion of law, particularly to a jury which doesn't know the law, presumably. So you'll say, these are the crimes charged. These are the elements of that. These are the legal defenses we'll raise. These are the rough elements of that. We will show you the elements that we need to prove for our side. So it kind of alerts the jury to what to listen for when they begin to hear testimony and so forth. And then, of course, at the end of the trial, you do the closing arguments where you wrap up and you say, see, we told you at the beginning we would show you these 5 things. We've done that through the testimony of this witness and that witness and the other witness. And therefore, we think you should deliver a verdict consistent with our narrative of the case. Obviously, the state has its narrative of guilt, and the defense has its narrative of innocence. This opening statement is different because in a self-defense immunity hearing, it's the person charged who files the motion for the hearing. So they're the petitioning party. At the trial, it's the state bringing the defendant to trial. So they're the state is the petitioning party at trial. That's why they go first. Essentially, the person who goes first is the person saying, why did I ask you all to be here? This is why. At trial, the prosecution is doing that. They're saying, why are we here? Because we've charged this person with these crimes. At the self-defense immunity hearing, it's the defendant who asked everyone to be there for the hearing. So the defendant goes first. The defense team gives their opening statement first at the hearing. And the tone of the opening statement is going to be a bit different at the hearing than it would be at trial, because at trial, we have the jury, lay people. At the self-defense immunity hearing, there's no jury. The judge is playing the role of both judge and finder of fact. So, and of course, the judge presumably knows the law, is more sophisticated in the legal context and so forth. So the tone will be a bit different, but the underlying narrative should be largely the same, the fact narrative that each side is going to deliver. And we'll hear from the defense. That's about 20 minutes. And then the state had about a 10 or 15 minute opening statement of its own at that self-defense immunity hearing. And I'll remind everybody, obviously, we're going to trial because immunity was denied at this 2017 self-defense immunity hearing. That doesn't mean that self-defense is doomed at trial. So at the self-defense immunity hearing, essentially the state had to disprove self-defense by 51% of the evidence, by a preponderance of the evidence. Or alternatively, you could imagine that the defense had to prove self-defense by a preponderance of the evidence. It's a seesaw, right? An evenly balanced seesaw. At trial, that's not the case at all. At trial, the state has to disprove self-defense beyond any reasonable doubt. Now, they don't have to disprove self-defense in its entirety. They have to disprove one of the 5 elements of self-defense, any one of the required elements of self-defense. If they can do that beyond a reasonable doubt, self-defense goes away. Again, you can get this infographic at lawofselfdefense.com/elements. So that's the mission of the state at trial. So the state has a much higher burden at trial than it did at the self-defense immunity hearing. The fact that the state was successful at the hearing does not mean it will be successful at trial. Now, when I play these opening statements, I have not listened to them myself. I listened to just a few minutes of it when I made my recording, my copy of it. I did listen to enough to know that the audio quality is horrific. And I'm sorry, there's nothing I can do about that. It's in the original recording. The video quality is not great either. So we'll try it. We'll see how it goes. But I have not listened to the entirety or even much of these opening statements. So this will be new to me as well. We'll be effectively all listening to it for the first time at the same time all together. I mean, I have some idea of what to expect from the opening statements, but I haven't heard the opening statements themselves. So let me open this up here, get ready to share this. And we're going to, just to clear up who the parties are. So the judge is Judge Susan Barthel. I'm not sure how you pronounce her name, so I'm kind of guessing there, but it's Barthle, Barthel. This is the judge who, I don't know how to put it. She I watched her during the jury selection last week. She seemed rather easily confused, to tell you the truth. So that will be interesting and very low energy. The prosecutor's name is Martin. So if you hear the name Martin said, that's the state prosecutor, the assistant district attorney in this case. For the defense, we have 2 attorneys. We have attorney Dino Michaels. He appears to be co-counsel, not the lead attorney. He's the one that wears a bow tie. So if you see a bow tie, that is defense attorney Dino Michaels. The lead counsel for the defense appears to be Richard Escobar. He's the one without the bow tie. They're both completely bald. So the bow tie is the key distinguishing factor. Interestingly enough, Escobar was retained as lead counsel by Curtis Reeves from the very start. So the day after the shooting occurred, when Curtis Reeves made his first court appearance, attorney Richard Escobar was there for that court appearance. It's not uncommon for defendants to go through a number of counsel before they get to the counsel they'll have for trial. But clearly, Curtis Reeves was happy with Mr. Escobar from day one, with attorney Escobar, and he's still lead counsel to this day, 8 years later. So this has presumably been a quite profitable case for attorney Escobar. So that's who we'll see. I believe it's the co-counsel Dino Michaels who delivers the opening for the defense. We'll see if he's wearing the bow tie. That's attorney Michaels, and I believe attorney Escobar did the closing at the end of the hearing. But we'll see in just a moment. I'll get ready to spool this up. And again, I'm watching this for the first time as well. So before we dive into that video, and it is about 20 minutes, and of course you can ask questions and I'll comment as we go along. What we're really looking for is the defense narrative, right? Why this was self-defense, why immunity should be granted. Of course, we know ultimately it wasn't, but this is the defense narrative of why this was self-defense, why immunity should be granted, and that they ought to frame that argument along the lines of the Florida statute 776012, the bases for the lawful use of deadly defensive force, either defending against grave bodily harm or defending against a forcible felony. We should expect to hear both of those laid out here. And then the state will give its opening statement and argue why one or more of those elements, required elements of self-defense, are disproven. At trial, disproven beyond a reasonable doubt. Here, only disproven by a preponderance of the evidence, less likely than more likely to be present. So that's what I would expect from these opening arguments. So let me open this up. So there we have Judge Bartle, and I believe this is Attorney Dino Michael. So let's go ahead and see if I can get this started. Well, that's not.
Mr. Reeves should be granted immunity in this case from criminal prosecution because he reasonably believed that the threat was imminent and that using deadly force was necessary. And in this sort of scenario where we're here on a stand your ground motion, it's unusual in that we're putting the trier of fact into the shoes of the accused. So in order to be able to properly examine this case, to analyze this case, we have to understand what Mr. Reeves was about and what his perception was at the time. This case is about perception. So it's important that we understand who Mr. Reeves is. At the time, he was 71 years old, retired.
So one of the things about self-defense, any claim of self-defense, is you have to consider really the totality of the circumstances from the perspective of the defender. So it's not necessary that the threat they're defending themselves against be real or actually exist, or that they're evaluating it accurately. Perfection is not required for a valid claim of self-defense. What's required is a reasonable perception of that threat. So someone could have a fake gun that can't actually kill you, but if you reasonably perceive it as a real gun, you're permitted to defend against it as if it were a real gun, even though technically you're mistaken. It's not a real gun. So what matters here is the defendant's, Curtis Reeves' perceptions of these events. And so he has to subjectively have that genuine good faith belief in the need to use here deadly force in self-defense. And that belief has to be objectively reasonable, that a reasonable and prudent person would have shared that subjective belief. But that reasonable and prudent person, that hypothetical person, is customized to fit Curtis Reeves. So it's not just a mannequin of a reasonable and prudent person. It's a person of Curtis Reeves' age and frailty and training as a police officer and experience in use of force. It's based on his abilities and disabilities. It's a reasonable and prudent person with his specialized knowledge, for example. So you have to take all those factors into consideration, whether he would have reasonably perceived a means to escape or that an attack was deadly, that a person similarly situated, age, ability, disability, frailty, experience, training, all that, would have shared the subjective belief in the need to use deadly defensive force.
He was married and is married. At the time he was married almost a half a century. His wife was next to him. She was 67 years old. He had 2 children. They're grown now. He was retired from a life of service to the community as a Tampa Police Department police officer. Dedicated public servant who, after he retired from the police department, worked as a director of security for Busch Gardens. He, at Tampa Police Department, and further during his employment at Busch Gardens, Mr. Reeves was trained extensively in the use of force, in the recognition of dangerous situations. He both learned by taking courses.
This is in the Tampa area of Florida, and the movie being watched was Lone Survivor, although I don't believe the movie had actually started yet at the time the shooting occurred.
Situations and to react accordingly. As a police officer, Mr. Reeves saw firsthand what danger lurked out there. He also saw firsthand that the hand can be as serious, can be a weapon, which can cause serious bodily injury. On the job, he saw broken orbital bones. He saw lacerations caused, broken bones. In other places, concussions.
So part of this is they're arguing, one of the things the defense wants to be able to argue, that this was a deadly force attack by Chad Oulson, even if he only struck him or imminently was about to strike him, Curtis Reeves, with his bare hand. That Curtis Reeves had, in his experience, seen people suffer grave bodily harm from bare-handed blows. Normally, the courts treat a bare-handed blow as non-deadly force, against which deadly defensive force would not be justified. But if Curtis Reeves has, through training and experience, actual knowledge, possessed that knowledge at the time of the shooting, that bare-handed blows can cause grave bodily harm. He'll be able to testify about that himself, but he'll also be able to bring in use of force experts to testify about that risk and inform the jury that, in fact, a punch thrown under such circumstances could be enough to inflict grave bodily harm. And if it's a threat of grave bodily harm, imminent grave bodily harm, that, of course, would be a basis to justify the use of deadly defensive force.
Injuries and death. He taught the people he was responsible for how to assess dangerous situations, how to react accordingly, so that they could go home safely every night to their family. He entered Tampa Police Department in 1966, made it to homicide robbery detective by 70. During that time, he also went to school. He graduated from University of Tampa, summa cum laude, in 1970. 76. He was tasked with the responsibility of creating a SWAT team in Tampa, first SWAT team in Tampa. He made captain. And all the while, he was still a family man. His children will tell you that he never brought work home, didn't discuss his job, didn't want to worry them, and was there for them. His son's going to tell you that I'm a police officer. I don't know how my dad found the time to play with me, to coach my soccer league, to do the things he did with me on a daily basis. Retired in 1993 from the police force. All the while, slowly suffering injuries, bad back, feet, shoulder, hands. Started working for Busch Gardens, had to retire after.
So now they're talking about his frail condition, physically frail condition, the injuries he suffered as a cop over time, just from aging. Because again, they want to be able to argue that what might have been a mere non-deadly force blow to a young, healthy person was a deadly force blow, one capable of inflicting grave bodily harm to someone with Curtis Reeves' frailties, age-related disabilities, and so forth. That he was exceptionally vulnerable.
Family man. He, at one point,
Yeah, folks, I think I have a Rumble account.
after
I'd have to look. I
retirement
have accounts on most of these
that
platforms, but I don't know how
once
to
his
use
daughter
most
had
of
a
them.
child,
And
that he
I'm
wanted
not
to take care
very
of the child,
good
help
at
care for the child, put
streaming
his
to
plans to
multiple
travel
sites.
to the side to
Still
take
trying
care
to
of
figure
that
that
child,
out.
his granddaughter Madison.
Yeah, by the way, folks, to the extent that we don't know all the facts in this case, it's only because the media hasn't reported them, because they're available.
He would play with her at the house, couldn't get down on the floor with her, so he slowly, Mr. Reeves was seeing himself deteriorate.
Yeah,
Things he
there's
used
the
to
other
be able
defense
to
attorney
do,
there on the left, and
woodworking,
he's not wearing the bow
opening a
tie. So that's
jar,
Richard Escobar,
things he
and
wanted
it's
to do, get down on the
co-counsel
floor and play with
attorney
his granddaughter,
Dino
lift her
Michaels,
up. He could
who's
no longer
giving this
do.
opening statement in
So
court.
he has a
Again, no
realization
jury here. This is
that
the
his body is
self-defense immunity
changing
hearing.
and he's getting old. So that's the man that went to the movie theater on January 13th. Went to the movie with his wife, Vivian. They were going to meet their son, Matthew, there. And when they got there, Matthew wasn't there yet. They went, bought a ticket, got some popcorn, drink, went to their seats. When they got in the theater, they looked for a place that had some seats together because they were expecting their son. They sat in the back row. The back row in this particular theater was against a wall where the Cine Bistro is. The court's going to be able to see that wall. The court's going to be able to see the seat that Mr. Reeves sat in. The court's going to be able to sit in that
This
seat
judge actually
and
went
see
to the
close
theater
proximity
and
to the
sat
row in
in
front
those
where
seats
Mr. and
as
Mrs.
part of
Oulson
this self-defense immunity
Mrs.
hearing.
Oulson sat in front of Mr. Reeves. Mr. Oulson was seated in front of Mrs. Reeves. Once the advertisements are over, notice comes on the screen, put away your phones. Mr. Oulson is using his phone, and the light is shining in Mr. Reeves' eyes. Mr. Reeves leans forward and asks him politely to please put away his phone. The answer he got was a curse-filled response. Mr. Reeves was taken aback by that. And he got up and went to the manager. And you can see, there is a video, and you'll see in the video that when Mr. Reeves gets up, he's moving kind of slowly, using the wall for balance, and he goes to speak to the manager. Thomas Peck is there. He's the manager. He's dealing with another patron, Dawn Marie Simpson. Mr. Reeves waits patiently at the desk, tells Mr. Peck that there's an issue with somebody who won't put away their phone. Very politely, very calmly, walks back to his seat. There's a video, you can see Mr. Reeves walking back to his seat. When Mr. Reeves arrives, and as he's passing by, he notices Mr. Oulson's put away his phone. So Mr. Reeves apologizes, tells Mr. Oulson something to the effect of, I see you put away your phone, I wouldn't have gone to involve management. That provoked a response that nobody could expect, a response that was so far out of the norm, so violent, an eruption where Mr. Oulson started to cuss, using the F word. And we know he did because we have several witnesses that are going to come in here and tell the court that he did. There were people in the theater that will say they heard Mr. Oulson's voice above the previews. The previews are loud, and it's dark in here. The court again is going to be able to see just how loud the previews are, how dark that theater is, to get some sense of what Mr. Reeves' perception was at that time. At a movie theater, you have an individual standing up, a 6'4" individual, who's younger than Mr. Reeves, standing in front of him, now cursing. Mr. Reeves tries to move back in his seat because now it appears that Mr. Oulson is coming over the seat. In the video, you will see that you can see Mr. Oulson's head and you can see an arm come into the video. There appears to be something thrown by Mr. Oulson. Mr. Reeves tells police after he's arrested, there was a blur of something he thought was a phone that hit him in the head. After the incident is over, there's a phone between Mr. Reeves' feet. In the video, frankly, nobody can tell 100% what it is. Mr. Reeves had some shoes on that had some reflectors, but nobody can deny that the phone was found between Mr. Reeves' feet, and that Mr. Reeves felt something hit him on the left side of the head. You're going to hear from a witness who's right down the road from Mr. Reeves who's going to say she saw Mr. Oulson make a throwing motion when he stood up. You're going to hear another patron who was seated in the room right before Mr. Oulson tell the court that he heard Mr. Oulson, and only Mr. Oulson's voice, loud, using the F word, and it alarmed him to the extent that he was starting to get out of the seat because he thought there was going to be a fight and that he was going to go over there and try to get involved and maybe try to stop the fight. But he didn't hear Mr. Reeves. You'll see in the video, there's a second attack. Mr. Reeves, in a dark theater, sees one hand come at him, sees an object that hits him. A short while later, as the barrage of cuss words continues, Mr. Reeves sees another hand coming forward. We see in the video that it's Mr. Oulson grabbing the popcorn bag. Mr. Reeves doesn't know what that is. Mr. Reeves sees a hand coming towards him. Grab the popcorn bag. The hand comes back, and then the hand comes towards him again and mashes the popcorn bag into Mr. Reeves' face. So he's seeing hands come at him several times. That's when Mr. Reeves decides that the only way that he can protect himself, because at this point he's back in his chair, because his training tells him that he needs to get as much distance between himself and the attacker as he can. He's leaning back in the chair, and at that point, fearing another attack, pulls his pistol and fires a shot. That shot goes through Mr. Oulson's.
Remember, folks, what matters here is
wrist,
not the actual nature of the attack.
Mrs.
What matters
Oulson's
is
finger
the
and into the
reasonably perceived nature of the attack.
chest of Mr. Oulson. So what you will see is, you'll see stippling on the hand of Mr. Oulson. You'll see some stippling on Mrs. Oulson's hand. And so in some way, the hands are lined up. Because Mr. Reeves is firing at a slight upward angle, the pathologist will tell you that it's reasonable to put Mr. Oulson bending over, thus coming over the seat. Importantly, in that whole sequence, when Mr. Reeves comes back to the theater after going to management, he picks up his popcorn and he sits in his seat. So certainly not the actions of somebody who is spoiling for a fight or doing anything other than apologizing and sitting back in his seat with his popcorn. Oulson's behavior terrified Mr. Reeves and terrified his wife who was sitting next to him.
So that's the subjective reasonableness, or actual state of mind.
After the shooting, Mr. Reeves puts the gun on his lap, show that he's no longer a danger. An off-duty Sumter County deputy comes, gets the firearm. Mr. Reeves is then arrested. After practically the entire Pasco County Sheriff's Office responded to the scene. As Mr. Reeves is being let out, he's taken to the car. He gives a couple of interviews to Detective Proctor. So he's cooperative. He's telling them that he thinks he was hit by something, thinks it may have been a phone. We know that Detective Proctor writes the arrest affidavit without ever having stepped foot in the theater. We know that Detective Proctor knew perhaps there was a phone found, but didn't know to whom it belonged on the floor between Mr. Reeves' feet. While Mr. Reeves is out in the car, the technician comes. It's going to photograph Mr. Reeves. Susan Miller, she notices there's a red area on his left eye, and so she documents it with a photograph. Interestingly, in this whole thing, Matt Reeves does come to the theater eventually. And when he gets there, he comes around the corner, gets on the landing of the stairs, is looking for his mom and dad, can't see him because it's too dark, so turns around and watches the previews. As he is watching the previews, there's a lull between two previews, and he hears his father in a frightened voice, a voice he never heard before, but recognized his father saying something to the effect of, "Get out of my face." Soon thereafter, there's a slight delay, but soon thereafter, he hears a shot ring out, and when he does, Matt Reeves is facing the area where Mr. Oulson is. He sees Mr. Oulson looming over his father, or where he learned his father was seated afterwards. He sees Mr. Oulson appear to step down as if he's getting off his seat or somehow moving down. Mr. Oulson walks down the aisle, and
Objections can be made during opening.
Lays him down and begins compression.
They're not often made because the lawyers have a lot of discretion in what they can talk about, how they can present things. They're just, and the jury's told that what they say in opening and closing is not evidence. But if they were to flatly misrepresent facts or law, or attempt to show, say, a video that had been altered and not stipulated to by the other party, all that kind of stuff could certainly be objected to.
20 of them together, put them in the left front area in front of the movie screen, gave them witness statement forms without giving them any instruction not to talk to anybody. We'll have witnesses.
This was the self-defense immunity hearing, folks, back in 2017. Not really a stand your ground hearing. There's not really such a thing as a stand your ground hearing, even though everyone seems to call it that.
Matthew Reeves will tell you that as they were seated at some tables in the lobby where there were other patrons, again, waiting to be interviewed, people were talking. People were saying, "This is over popcorn." And he took his mother into another room to get away from the area. The point of that is there was a horrible contamination of the witnesses. And even though there were all these police officers, nobody tried to do anything to stop it. Nobody gave them any instruction not to speak to anyone. Now, there is a video in this case. And what's interesting about that is that night, Pasco County Sheriff's Office doesn't ask to see any kind of surveillance. It takes them 2 days to go back. In the meantime, Cop Theater had taken the hard drives out back to their headquarters. So we have Mr. Reeves arrested, and we have the Sheriff's Office not even trying to look at the video until 2 days later. And when they do, they send somebody not from cyber crimes, not from some kind of computer tech division. They send a guy who's pretty good with IT, Aaron Smith.
Curtis Reeves was denied bail for, I think, the first few months after this event, a decision that was affirmed by 2 trial judges, but then appealed and reversed on appeal. He was granted bail. He's been on home arrest for the last 8 years.
His spine, the arthritis in his hands, the narrowing of his spine where the nerves pass through. So there's documented evidence that there is this degeneration happening with Mr. Reeves. Hear from an aging expert, Dr. Donna Cohen. She'll explain how
an aging expert, again, to emphasize this frailty, that this needs to be the conduct not just of a hypothetical, reasonable, and prudent person, but a hypothetical, reasonable, and prudent person who's frail from police-related job injuries and from age, and is exceptionally vulnerable to injury, such that what might not normally be a grave bodily injury attack, a deadly force attack, is deadly force towards this exceptionally frail, vulnerable defendant. And therefore, he would be justified in using deadly defensive force.
Process of downloading and why the images look the way they do, and talk to the court about
can the dead guy's wife sue civilly? She did sue a number of people. I'm not sure she sued the defendant yet. I know she sued the theater
from a crime scene reconstruction
on a couple of grounds. One is that they failed. Apparently, the theater had stickers on the doors saying you can't bring a gun onto the premises. Now, in Florida, that doesn't make the carrying of the gun
kind of a unique
into the
situation
theater a crime.
because Mr. Reeves
Technically,
is
you're
both
committing a civil
an old
trespass,
person,
but
he's also a
you know,
retired
it's probably
law
never
enforcement.
actually enforced unless they find out you have a gun, which shouldn't
That's
happen.
important because of his
But
training.
she sued the theater,
and his
claiming they did not
experience
effectively
in
enforce
knowing
their no
what
gun
is
policy,
happening in front
and also
of
that
this
they did
case.
not respond
Chad
to
Oulson's
the
looming over him,
confrontation
he's coming over the seat,
adequately when
is
they were
acting
approached by Curtis
irrationally,
Reeves
is
when he left the
acting,
theater to complain to a manager
menacingly,
or
is
a
acting
theater employee
angrily in a
about
movie
this
theater,
dispute. That
of
if
all
only
places.
they had come
And
and
coming towards
mediated
him,
the dispute,
Mr.
that
Reeves
this shooting would not have happened.
knows what he has to do in that particular case.
But
He
if
acted reasonably
certainly if
because
he's
of his
found
background,
guilty,
because
I would
of his
expect
training,
the wife to sue for
and
wrongful
because of his
death in civil
situation.
court and win. You know, if the death has been proven to be unjustified beyond a reasonable doubt, the criminal trial standard, it's certainly been proven by a preponderance of the evidence, which is the civil
So for
suit.
those reasons, since we're looking
Standard.
at Mr. Reeves' perception,
And there wouldn't be any problem with statute of limitations.
and,
Statute of limitations, the statute of
did act
limitations is
reasonably because
effectively
of all the
told,
things that I outlined
paused, the clock stops counting down, as long as the person has been made aware that they're subject to being sued. They've been put on notice, and that would certainly be the case here. Okay, so that was the terrible
Mr. Reeves,
defense opening. Terrible in terms of, frankly, in every respect. It was terrible in terms of audio and video quality, which is not the fault of the attorney, but very, very low energy by defense counsel. I know they're not talking to the jury here. There is no jury at the self-defense immunity hearing. It's only the judge. But man, I would have brought more energy to this opening if it were me representing a client there. That was terrible. So, yeah, and he said popcorn a lot. I would have stayed away from popcorn as much as possible as well. Yeah, so I'll do the defense also did their opening. It's only about 13 minutes long. I'll play that. Then I think I'll answer whatever questions people have and wrap up. There is a lot more video from the self defense immunity hearing, but frankly the quality is so poor that I'm not sure I can. I want to subject you or me to more of it. But I think we ought to hear at least because it's so brief, the state opening. So let me pull that up. So the defense just finished its opening. Now the state will get up. This is Assistant DA Martin will represent the narrative of the state. Why immunity should be denied. Why this was not self-defense by a preponderance of the evidence. Also a very low energy guy, unfortunately.
On January 13th, 2014, it was a date day. It was a date day for Nicole and Chad Oulson. They also have children. One small daughter, then daycare. And on that particular day, they took it upon themselves to take her to the daycare, drop her off. And then they went to the mall, had some quality time together as husband and wife, and they decided to go to the movies.
Oh, so they went to a bar first.
Times that they agreed on
Chad and Nicole Oulson.
To see,
so maybe he was a little juiced at the theater.
And I believe what you'll hear from the testimony of the witnesses, that even though Ms. Oulson doesn't know exactly when Mr. Reeves arrived in the theater and sat directly behind them, they were there first. They settled in, they were eating popcorn. At some point, Chad Oulson left and got some Twizzlers and maybe another Coke. Chad Oulson does have a cell phone. He had it in the theater. He had the cell phone on. Now, what is significant is the timing. Now, you will be able to see during the theater view exactly the lighting conditions in the theater. It'll be set up at house lights and go to turn mid-1. That is the light setting so people can walk into the theater, so that they don't fall down and trip over each other trying to get to their seat. It is not the very dark lighting that you would anticipate for the feature movie. So what happens during the time period when the feature, when the trailers are on, and when we have the house level at a setting where people can see their movements and where they're going. People are talking. People are coming in and disturbing everyone while they're getting to their seats as the trailers are going on. Mr. Oulson is, in fact, using his phone in some fashion. There won't be any testimony that he was talking on it, but the screen was illuminated. Now, at some point, Mr. Reeves does take a seat behind Nicole. Now, I believe what you're going to hear from the testimony is that Chad Oulson was sitting in his seat and Nicole Oulson was to his left. Now, the seats in the theater are just a little bit, not right behind each other, but a little bit off to the side for viewing purposes. But for the purposes of me explaining it to you, Mr. Reeves was seated behind Mrs. Oulson, and Mrs. Reeves was behind Mr. Oulson. At some point in time, while the trailers are playing, while people are still walking in, while people are still stepping over one another, getting to their seats, while other people are still talking among themselves, Mr. Oulson has his phone out and he's doing whatever you'll hear in the testimonies that he's doing.
Yeah, apparently he was on the
Reason
gambling
Mr.
websites,
Reeves takes an
not
exception
texting the babysitter.
to the light of an iPhone.
He said he was texting the
being
babysitter, but he was
played
lying
while
about that.
trailers are being played. And at this point that Mr. Reeves has a non-consensual contact with Mr. Oulson. Not once, not twice, but more likely 3 times, but at least twice. And during that time period, he leans over significantly into Mr. Oulson's face and asks him to get off the phone. I'm not going to try to tell you what the witnesses are going to say about the demeanor, how it was said, or what words were said. You'll hear that during the testimony. But suffice it to say that Mr. Oulson took exception to that non-consensual contact. He wanted Mr. Reeves to just leave him alone. Mr. Reeves then took it upon himself after the at least 2 contacts with Mr. Oulson to then leave and go complain to the manager.
It's really deceptive. The prosecutor
Well,
likes to
Mr.
use this phrase contact
Michael didn't tell
because
you in
it
his
could be
scenario
understood to
that
mean
when Mr.
physical
Reeves came
contact.
back
I don't believe there's
and
any
walked behind
evidence that
Mr. Oulson,
Curtis Reeves was
he did
touching
not see the
Chad
phone.
Oulson, that there was physical contact.
Whatever was
He's saying contact to mean
disturbing Mr. Reeves
spoken
to the
words.
point that he felt that he
But he
had
may
to
want
have
to
this
create the
non-consensual
impression of physical
with
contact
Mr.
if he
Oulson.
wants to make
Not
a
once, but not
provocation
twice.
with intent argument
Whatever
or
was going
a
on
mutual
was so
combatant
significant
argument
to Mr.
on the
Reeves
element of
that he
innocence.
felt that he had to get up out of his seat and miss the previews that the light in his eyes was disturbing that he couldn't watch. He went and complained to the manager, and when he came back, that was over. The phone was out of the way. Mr. Reeves told that to law enforcement. As he's walking
So here the
back to
prosecutor may be
captain,
trying to argue
I
that
did
whatever
not see the
Oulson
phone.
had done initially,
Now, whether or not
when
it was an
Curtis Reeves
apology
came back from the
or
manager,
what
the
statements
first
were made,
encounter
we'll
was
hear from the
done, and
witnesses
Reeves started
how
a
Mr.
second
Reeves
encounter. He was
then
the provoker
rekindled
there.
that contact with Mr. Oulson, knowing that Mr. Oulson was taking exceptions to the non-consensual contact to start with. He rekindled it. Said, words to the fact, hey, I see you put your phone away, whatever, you'll hear from the witnesses. You're going to hear the witnesses through Nicole Oulson and some of the other witnesses that observe certain snapshots in time. You're sitting in the movie theater and the witness will tell you, we were watching the preview. We could see what was going on between these 2 guys. Maybe we wanted to look, maybe we didn't, but every time they looked over, they saw a snapshot in time of what occurred. And each of the witnesses have various different snapshots that they saw. And it's for us to try to figure out, can we put that together for some type of meaningful event that took place so we can make a decision in this case. But the bottom line is that after that comment, you will see in the video Mr. Reeves leaning forward again. So this is the second time after he comes back to the manager, then he makes the non-consensual contact with Mr. Oulson after the event that he complained about. Mr. Oulson.
This is
You'll be able to see
very
the
weak,
video.
very weak opening by the
And the
stage.
video is also snippets of event. There's a motion
Marcel
sensor camera.
Dufour,
There
with it
is
looks like
some no
maybe that's $5
recording.
Canadian dollars. I don't
For a
know.
second.
Thank you very much. In any case,
For
he
5
writes,
seconds.
he should have left.
But you have
I guess
to keep
Curtis
that in
Reeves. He
mind
should have
as
left.
you watch
Ego's the
the
enemy of us
video,
all. Now
as
someone is
well,
dead
so you
and
can
another is on
discern
trial.
And put
Who
proper
wins?
meaning
No
to the
one.
content of what
I
you
certainly
see the
concur. If it
participants
were
in the
me
video
and
doing.
the phone thing was
But it's at that
bothering
point
me
that, again,
sufficiently
Mr.
that,
Reeves,
well, to any
the
degree,
protagonist,
really, I would have left.
the non-consensual contact.
If anything, I
with
might
Mr.
have
Oulson,
certainly left to a different seat,
again
maybe
makes
someplace else in the
contact,
theater
and
that
Mr.
I
Oulson
wouldn't be subject to the phone,
Now,
or
what
left
you're
the
going to
theater,
see
gotten a refund or a
video
coupon to come back
is that
another
there
day.
is a grabbing of the popcorn.
I
There's
put a
a
high
hand that
priority
comes
on
in,
avoiding
comes
even the
back out.
possibility of physical
Popcorn
violence,
is
because I
tossed.
do carry a gun for personal
Popcorn
protection.
lands in the
And
area
the
of
last thing
Mr.
I want
Reeves,
in the world
and the
is to
hand
find
comes
myself
back.
compelled to use
And
that
what you're
gun
going to see when you
in
start
self-defense.
sequencing
But
the event,
he's not
is that
obliged
as
to leave,
Mr. Oulson brings
and he
his
doesn't
hand
lose
back
self-defense
from
because he didn't leave.
tossing the popcorn.
So that he
that
should have left is really
Mr.
not a
Reeves
legal
is in the
issue for this
process of
case.
drawing his pistol.
Yeah, this is just the
At
judge
that
here.
point,
Self-defense
and
immunity
after
hearing. There is no
Mr.
jury. The
Oulson
judge
is
will be making the
retreating from the
factual
immediate area of
determinations as
Mr.
well as the
Reeves.
legal determinations.
He is no longer in his space. He's in his side of the aisle. Mr. Reeves is pulling his firearm from his pants pocket. He is leaning forward. He presses that firearm towards the area of Mr. Oulson and shoots him right in the chest, in the area of the heart, just above the nipple line.
Oh, he had to say nipple.
The significance of that, Judge, is what you're going to hear from the witnesses, is that prior to the shot being fired, Mr. Reeves said, "Throw popcorn on me, will you?" Bang! When we talk about self-defense, when we talk about stand your ground, the court is well aware that what we're talking about is it reasonable. With the reasonable person, believe under the circumstances, knowing what Mr. Reeves knows, was it reasonable and necessary? Was it reasonably necessary to prevent immediate great bodily harm, death, or forceful felony? If I could use the analogy of Goldilocks. Too hot, just right, too cold. When we talk about standing your ground, it has to be.
I wonder if he's got my book, because
It is
when I talk about the
correct.
element of imminence, I use the Goldilocks
Once
analogy as
the
well.
popcorn is grabbed, once the popcorn is tossed, that is over. He can't prevent that. by
So here the
shooting
prosecutor's
Oulson.
attacking
As
imminence.
Mr. Oulson
The
is
fight was
coming
over. It was
back
no
in
longer a fight. There was no
submissive,
longer an imminent
non-aggressive
threat. The
stance,
window of imminence had
with his
closed.
hand coming back towards him, it is Mr. Reeves who made a decision.
Yeah, unfortunately, this prosecutor has proven to be very
By
low
his own
energy as well.
statement, he knew that the popcorn had hit him in the face. By his own statement, he says, "Throw popcorn in my face, will you?" His conduct is nothing but retaliation for the very embarrassing act of having popcorn from a former police officer who is used to having people do what he said. It's a sad situation. It's very sad. Was he scared? Yes. Of course, well aware of being scared doesn't make it reasonable. You have to look at the time of the threat. Was there anything for Mr. Reeves to prevent after the tossing of popcorn? What was it that was taking place? It can't be an assumption, well, I got popcorn tossed on me, a bag, fluffy popcorn is now on my body. Then the next thing that has to occur is this guy coming over the seat and going to pound the crap out of me. That's the assumption that can't be made. You have to look at exactly what the actions of Mr. Oulson were. So when we look at this case, and when you hear the witnesses and the cross and the testimony that's going to be put on, I think you'll be able to see that first, there was no cell phone fraud. I think that's going to be clear once you hear all the testimony. It wasn't fraud. There is no injuries consistent with Mr. Oulson's face. There's a small, possibly abrasion on his eyelid underneath his glass. There's nothing to indicate that a cell phone was thrown and hit him in the face. And through the other testimony and extra testimony, I think that'll be clear. What you have is the grabbing and tossing of popcorn and retaliation by Mr. Reeves of shooting of Mr. Oulson. It's the retaliation. Applying the Goldilocks rule, he was too late. What he did was after everything occurred and there was nothing to prevent. And under that circumstance, Mr. Reeves is not entitled to immunity. Thank you.
Thank you.
All right. So that was the state opening. Boring, unfortunately. All right, folks. So I do want to remind all of you, we have this popcorn bundle we've put together during the duration of this trial. Our 4 best-selling courses available at 60% off. Save yourself $300 while we're running this. You can find that at lawofselfdefense.com/bundle for our popcorn bundle. It's our Law of Self-Defense Advanced course, which is normally $200 all by itself. And then 3 of our other best-selling courses, normally each $100. So an additional $300. We're giving those to you for free when you buy the advanced course for the normal price of $199. So instead of $500, it's $200. Pretty good savings. You can find that at lawofselfdefense.com/bundle. You can also get a free copy of our best-selling book, The Law of Self-Defense. Real physical book, folks, couple hundred pages. We do ask you to pay the shipping and handling, but we eat the cost of the book at lawofselfdefense.com/free book. You can get the hardcover of that book. Very, very nice book. Autographed by me personally. I sign all the hardcovers. These are not free. They just cost too much to get produced to be free, but you can get these at lawofselfdefense.com/gethard for the hardcover of our book. They look great on the bookshelf, folks. Make great gifts too. And if you do nothing else, I would urge you to at least make sure you get our infographic on the 5 elements of self-defense law: innocence, imminence, proportionality, avoidance, and reasonableness. This is free, folks. Doesn't cost a penny. You can download it as a PDF at lawofselfdefense.com/elements. And if you happen to want a poster size version of this, we have those as well. Those are not free. We have to print those up and ship them. But if you have a classroom or somewhere you'd like a poster size version of that infographic, you can get that at that same URL, lawofselfdefense.com/elements. We might ship, we do ship books. I see someone saying they don't ship outside of the US. We can't ship outside the US for the standard shipping because it costs a fortune to ship books outside the US. But if somebody wants one and wants to pay the extra shipping, we're happy to send it. I'm not sure why you'd want it outside the US. We only cover American use of force law, but for some reason we do sell quite a few books overseas. But I just warn you, the shipping gets costly. So if you're interested in that, you would have to contact support@lawofselfdefense.com and talk with them about where you are, where you want the book shipped, and what the shipping would cost, and make a decision from there. But certainly the free book for the standard shipping is only within the US. All right, folks, I think that's about all we have. Again, to remind all of you, if you carry a gun, so you're hard to kill. That's why I carry a gun, so I'm hard to kill. My family is hard to kill. Then you owe it to yourself and your family to make sure you also know the law so that you're hard to convict. I hope you'll join us again tomorrow for the actual trial. Opening statements are at 9 a.m. Eastern time. I believe we'll be streaming it over at Rakita Law. I think Nick is planning to cover the trial and have me join him. But in the event he decides not to do that, we will definitely then alternatively be streaming it here at Law of Self-Defense. So I imagine we'll send out some kind of notification about that later today or first thing in the morning. Things do start up pretty early, however, 9 a.m. Eastern time for opening statements. Probably will be much along the lines of what we've just heard, although I believe at least the defense is planning, and I think the state as well, to show video to buttress their opening statement during opening tomorrow morning. So that'll be interesting to see. All right, folks, until tomorrow morning then, if you're watching the Super Bowl today, enjoy that. Have a good time. Please don't drink and drive. Be safe and take care. Bye.